Any mention?
Therefore, respondent number 2 and 3 in writ petition.
From this side.
My lord, in writ petition number 15313 of 2008, we are for the respondent numbers 2 and 3, Haldia Development Authority. My lord, I am led by Mr. Kolol Basu. Today we are not prepared for the matter.
Let the matter be called. Which is the item number?
Item number 3, my lord.
Wait. Wait, when the matter will be taken up. Wait.
Wait, please, your lordship. Lordship, this matter is pending for a long time. WPA number 12514 of 2016. And when your lordship heard this matter, number of officials changed. This matter got delayed. Now it has come back to you. We see some ray of hope. That is why for kindly for listing of the matter and can has been filed.
For listing?
For listing, there is it is not in the list and can.
What is the can application?
Can application that a new situation has arisen. They said that in which there is a embargo and stay order, but there is actually no stay order. Out of that, one allotment they have already issued, but for rest of the persons they have not issued allotment in the name of the stay order of the lower court.
One year देखे. Suit has been compromised.
In the name of compromise of the suit, they are not compromising since 2010.
Yes. List for vacation for the paper spell list for the
Item number 1.
Kindly do not take it up today, tomorrow or next week, whenever you launch your business.
Till after vacation.
After all interval, we are listed this matter, my landed trade also came. Kindly take up tomorrow, at the top. Kindly take up.
Not today.
Item number 2.
Come for the petition. Is it new contempt application? First time new application. This here with the order of the file order.
In what happened?
Now, not yet been disposed of, not yet been. The adamant, the Pradhan is the very, so many work about the Honorable High Court.
Give a notice to the state and the respond number. Contempt petition. No, contempt is contempt arising from order dated 15th April 2024. Now, order dated 18th October 2024 passed in WPA 12761 of 2024. It is Mr. Swensol and advocate appearing for the petitioner. Petitioner applicant হবে না? Applicant. Applicants submits that in spite of communication of the order of this court, the representation of the petitioners have not been disposed of by the Huh? Has not been disposed of by the court contender, the respondent number 4. Pradhan Hijol Gram Panchayat. Para, the applicant is directed to serve notice upon the state as well as contender respond number 4 to Pradhan Hijol Gram Panchayat and file affidavit of service on the returnable date. Please this matter. কবে আসবে প্রীতম বাবু? হ্যাঁ? Seventh January.
Then 8 or 9 after 7th, my lord. After 7th, they need to.
Or 7th.
8 or 9 days.
9th দেখো কি আছে? 10th দিয়ে দিন 10th. 10th January. Give a notice.
Item number 3,
Yes.
For respondent numbers 2 and 3, that is Haldia Development Authority. My lord, I am led by Mr. Kolbul Basu. My lord, we are not
Kollol Basu is for?
That-
He is appearing for whom?
for 2 and 3, my lord.
2 and 3. Haldia. And you are for?
My lord, I'm appearing for the petitioner, my lord. Your lordship would recollect Mr. Abhutosh Majumdar had concluded his submissions.
Yes.
My lord, only one thing, my lord, if your lordship kindly marks the matter part hard because the arguments of the petitioner is concluded.
No part heard. After vacation we take it up. Nothing will change.
But kindly marks it part hard, my lord, because otherwise, my lord, the petitioners would be in great difficulty. My lord. Your lordship kindly considers.
Your lordship had the determination, my lord,
After that, no.
Go to number 654, my lord. Mr. Majumdar then also stated in submission, my lord, that the determination changed, my lord.
My lord,
No, it was not concluded at that time. It was in the process of.
Your lordship will kindly pass an order marking it part. Your lordship has concluded the hearing of the petitioners. Kindly.
Right, no, no.
Otherwise, the petitioners would be in great difficulty. My lord. Kindly. My lord.
Miss So-and-so learned advocate appearing for respondent numbers 2 and 3. Huldia Development Authority seeks accommodation. List this matter on 6th of 6th. Oh, pardon, করে দেবো?
Kindly. My lord.
Mr. Choyan Gupta. Huh? Pardon, no, it's 80. না এটা অ্যাসাইন নয়। এটা কি অ্যাসাইন্ড আছে প্রীতম বাবু? এটা কি অ্যাসাইন্ড গ্রুপ 1 এর পার্ট 1 মার্ক করুন।
I'm so grateful, deeply obliged.
The matter is marked part 1. Yes, next.
Item number 4,
Four.
Order, my lord, dated 3rd of February, my lord,
Huh?
2024, where your lordship dictated, where the state submitted the valuation of 1 crore 30 lakh rupees, my lord. That is still pending compliance report is.
So what is the order passed?
3rd of
Should we consider?
February 2024 order is my lord, by your lordship.
What is the position?
Many of the accommodation, my lord, but they do not take any instruction.
Where is the compliance report?
Already taken.
In terms of order, it is a report was sent to you due to this. The land has been used for what purpose?
For the purpose of my lord, arsenic department.
Huh?
PA.
No, you can do- Rehabilitation. Oh. Something order.
State willing to purchase the land, they have submitted the valuation. Yes, with the valuation, my lord, your lordship passed an order dated 23rd of February 2024.
Mr.
May I have a copy?
Prashanto Bihari Mahato, learned advocate for the state respondents, submits that already process has been initiated for direct purchase. However, for execution of the sorry, it again. However, the requisite fund has not yet been received for execution of the purchase deed. He seeks for extension of time for execution of the purchase deeds. He files copy of the letter of the district magistrate and collector Murshidabad dated 12th December 2024, which is taken on record. First week of February থেকে রেখে দিন।
My lord, may I have a copy?
By February. Give a copy of this letter, এটাকে xerox করে দিন তো। একটা xerox করে দিয়ে দেবে, একটা রেকর্ডে রেখে দেবে। এইটা ঠিক রেখে দিন তাহলে রেকর্ড, এটা রেকর্ড। You have a copy of this?
Item number 5,
February first week এটা করে দেবে।
My lord, I'm paying for not this week on behalf of Chandan Mishra.
February first week এ ডেট দেবে।
For the respondent.
List this matter in the first week of February. Restoration. Restored. Everything stands disposed of within the service of fixing the matter. Yes. Who is for the petitioner?
Item number 6, I am behalf of the petitioner lordship led by Mr.
Number 5. Last week of February.
কোনটা বললো first?
Mr. Amit Kumar
আরে
Pan lordship.
আহা কি করছেন? First week of February হচ্ছে item number 4.
item number 4. এটা item number 5 চলছে।
Number 5.
5. 5. So who is there? Who appeared for the চলে গেছে? Not today, থাক। Let it come. The pleadings are complete in this, Mr. Talukdar?
The last restoration was allowed.
Okay.
And the matter to be heard.
Who is for the petitioner? Mr. Chandan Mishra is for the petitioner.
Yes, yes.
Kindly just verbally intimate him this matter is I'm making it not today. Let it come up tomorrow.
He was asking for time for not this week. Was saying
Not this week means go. Tell vacation for a date. On the prayer of learned advocate for the petitioner, release this matter 1 week on reopening of the court after winter vacation.
Item number 6,
Item number 6, I am behalf of the petitioner led by Mr. Amit Kumar Pan lordship. Lordship, for some personal difficulty, he has left court lordship. Kindly fixed it at 2 p.m. lordship.
No, kindly fix the hearing matter no, the after vacation.
No, lordship, then kindly not today lordship. It is very urgent matter lordship. It has been going for so long lordship.
No, not this side of the world. Mr. Swanso, learned advocate for the on the prayer of learned advocate for the petitioner, release this matter 1 week after the vacation.
Deeply obliged.
item number 7,
Lord, I appear for the KMDA. Well, this will require some time.
Let us start. Who is for the petitioner?
Legal points, my lord. Yeah, you are. Then petitioner is challenging the acquisition process after an inordinate delay.
When was the acquisition was undertaken? In the year 1987. Hunda Das Adhikari. None appears on behalf of the petition. On the last occasion, that is 5th December 2024, the petitioner was not represented. In view of the above, the writ petition being WPA 2260 of 2014. So good, Shana. How many times this was dismissed for default, again restored?
Again restored, and again
Results. WPA 2260 of 2014 stands dismissed for default. All collected applications, if any, stands with interim or writ stands vacated. Urgent photostat certificate code. Can one, can two disposed of? Dispose of হয়ে গেছে। এটা কিসের দেখি অ্যাপ্লিকেশনটা? ক্যান ওয়ান কি করে ডিসপোজ হবে? না, ডিসপোজ অফ হয়নি। Shall be disposed of along with the writ petition. আর টুটা কি হয়েছে? টু বলে কোনো অ্যাপ্লিকেশন নেই? এই দেখো আগে টুটা আছে কিনা, তুই আমাকে বলো। টু কোনো অ্যাপ্লিকেশন নেই? লিস্টে কি করে এসছে? আসেনি? এই ঠিক আছে, ওটা আইটেম নাম্বার 6, ওই আইটেম নাম্বার 6 একটু অ্যাড করে দিন তো। Inadvertent typographical error has crept into order date. It বলো, ডেটটা বলো। 2nd December 2024. Mentioning can 2 of 2023 in the cost title, na? 2 of 2023. Mentioning can 1 of 2022 and can 2 of 2022 in the cost title. 23. The Can applications as aforesaid shall be read as Can 1 of 2023 in the cost title of the said order. The other portions of the order shall remain unaltered. এইটুকু add করে দেবেন আজকের order. Next.
Item number 8.
8.
For the petitioner, my lord, in this matter.
Item number 8 to 26 relates to the same issue. But kindly remember what the letter
8 January.
But that's the order passed by your lordship. I have a copy. I have copy.
How many matters are there on 8 January?
Pardon?
How many are there in 8 January?
There are my lord,
Almost
19 total.
19 and 8 to 26. Ach.
Yes, 19 total.
Yes.
Same issue. The order I have handed over the parties to Nodia.
And this is Murshidabad.
Murshidabad.
Okay.
It will be convenient for your lordship.
And this, the department is same.
Department is same. Lord.
PHE.
PH. Only one lord, item number 16 in respect item 16. I will hand over the opposition right now to your lordship and the original, and I will hand over.
In all these matters, you are representing state.
No, Lord. I have been instructed to represent Lord, as because Lord, there will be no effective.
So what I do is I call the items one by one and find out what is the stage of the pleadings.
No, Lord.
Huh?
Everything Lord, I have been told that in all the matters, pleadings have been exchanged except 16. 16.
Okay, 16 written. ডাকুন তো one after the other. 8 আসুন. Mr. Mr. Jayanta Samanto, learned advocate for the state, submits for listing the matter on 8 January 2025, where the other writ petitions are listed to appear, dealing with this similar point of law. In view of such submissions, list this matter on 8 January 2025.
Okay.
8 January 2025. 9. Nine.
Item number 9.
Yes, opposition file. Same order. Right. We do same order. 9 same. 10.
Also same.
Item number 10.
Same order.
Item number 10. 11.
ওই অ্যাপিয়ারেন্সটা নিয়ে নিন।
অ্যাপিয়ারেন্স গুলো কি দেবেন?
11 10টা হয়ে গেছে।
Yes, ma'am.
11 সেম অর্ডার, ওই অ্যাপিয়ারেন্সটা মিস্টার শীর্ষের মতো।
11 to 4.
Not same.
Item number 12.
Not opposition. In this you have filed your report, not opposition. Like it was same. The other side, the other. Correct.
Item number 13.
Who is Mr. Samanto? Same order, Mr. Ansar Mondal is subleader. Next.
Item number 14.
I'm the state.
State, who is for the state? Same.
Item number 15.
I am the state, my lord. Same, my lord. 8.
Same.
Item number 16.
16 below, I am filing the opposition. Have the copy by the. Kindly recordable, I will.
State,
Finally recorded, my lord.
state respondent
File.
files, sorry, affidavit of opposition filed on behalf of respondent numbers 3, 5, 6, and 7. State is taken on record. Copy served. List this matter on 8 January 20.
In the meantime, reply. In the meantime, reply.
We
Opposition
are not
has
filing any reply, my lord. We
You will not be filing any reply?
Oh.
Okay. তাহলে ওটার উপরে করে দিন. Learned advocate for the petitioner submits that his client will not file any reply to the affidavit in opposition of the state.
Fine.
List this matter 8th. Complete হলো.
Item number 17.
I am the state.
Same. Okay. Same.
Same order 17. Item number 18.
এই কিছুই গন্ডগোল লেগেছে. Where is your report or affidavit in opposition? 18.
My lord, in this matter, affidavit of opposition has not been filed, my lord.
18 is Mr.
18.
18 Mr. De.
My lord, I have got a statement.
Where is your report or affidavit in opposition? Again, not today.
In the meantime, it can be exchanged. Like the meantime, it can be exchanged. Kindly directed.
Mr. Prashanto Bihari Mahata, learned advocate, seeks extension of time to file affidavit in opposition. Let such affidavit in opposition be filed by the returnable date. Release this matter on 8 January.
Item number 19.
আগের মতো সেম.
Item number 20.
Was for the state.
Item number
20 who is for the state?
20 I have for the state.
ঠিক আছে.
20 is
What
similar.
of Mr. Der?
1 is
Later.
also the similar.
Huh? Same one.
Item number 21.
Similar, madam. Opposition has been filed, madam.
Copy has been served.
Yes, madam.
Opposition you have received.
Yes, madam.
Same 8 January.
Item number 22.
Reply non appears on behalf of the state. Mr. Dey, you will appear in this case?
Yes, madam. I've given the name.
22 th same order.
Item number 23.
23. Complete আছে মনে হচ্ছে। Filed by the state or filing reply. Same order.
Item number 24.
Similar issue. Item number 24.
In this matter, my lord, affidavit in opposition has not been filed.
Where is the affidavit in opposition?
In the
Mr.
last day, my lord, 6
Ansar Ali.
December,
Where is the affidavit in opposition? Mr. Ansar Mondal and Advocate State Response seeks extension of time to file affidavit in opposition. Let such affidavit in opposition be filed by the returnable date. List this matter on 8th January 2025. এটা একটু এ রাখবেন, প্রত্যেকটা কারেকশন করতে হবে 20।
Item number 25.
25. Same order.
Image 50.
yes,
Item number 26.
The state Mr. Dey is leading me. Same. The order to দিয়ে দিন। হ্যাঁ, এই যে দেবনাথ বাবু অর্ডারটা দিয়ে স্টেটের কে আছে স্টেট
Order-টা
ফ্লেক্স
Item number 27.
Your Lordship, I am appearing on the behalf of the National Highway Authority.
intimate
Your Lordship, on the last
Let such
occasion,
report
Your
inform
Lordship
me by
directed us to
writing.
file a report in the form of an affidavit. Your Lordship, I am praying another 2 weeks time to file an affidavit. Another 2 weeks time for filing.
File what?
File a report. Another 2 weeks.
Exception.
I am praying for another 2 weeks time to file a report, Your Lordship.
How long this will go on? State? You are for the state? None appears on behalf. देखिए, हाँ, Noreen. Who is this person? Noreen Ghosh Dostidar. He is a panel advocate. His name is not recorded in any of the orders. He is in the panel. He is in the panel. Yes. Reply to what? State. If he has not filed the opposition, there is no question of filing reply. Then let him serve. Let him serve. It has to be filed on record, then I will take your reply. If it is not filed in the record, what is the use of taking it? এটা কি আছে এখানে advocate? Mr. Sen? Mr. Naren Ghosh Dosidar is in the panel of the state. Huh?
Room number 9.
You have checked that he is appearing in this matter? Okay. Copy of the notice dated 12th November 2024. আচ্ছা, ওটা কেটে দিন। Mr. Mihir Kundu, learned advocate for the petitioner, submits that pursuant to order dated 26th November 2024, he has served notice upon the learned advocate for state respondents. He files copy of the notice dated 12th November 2024, which is taken on record. None appears on behalf of the state respondents. Mr. Swanso, learned advocate for the respondent NHAI, seeks extension of time to file its report. Let such report in the form of affidavit be filed by respondent NHAI within 1 week of reopening of court after winter vacation. Exception to such report, if any, be filed within a week thereafter. Is this matter? NHAI the respond number 5 করে দিন। 1 week after the vacation. 1 week on reopening of.
The report be filed within
1 week. 1 week on reopening of the court after winter vacation.
matters shall appear lordship.
After. Exception, if any, be filed within a week thereafter. এই ওটাকে 2 সপ্তাহ পরে করো। হ্যাঁ? ওটা 2 weeks করে দিন।
Item number 28. Lordship, I beg to appear on behalf of the petitioner. Lordship, from the last 4 orders, Lordship was pleased to direct them to produce a possession certificate, my lord.
Sir, is appearing in this matter, but he's engaged in proof number 1. On his behalf, my lord, I'm praying for not to.
Where is the possession certificate?
Lord, I am not in this matter, my lord. Mr. Debra is appear.
Let him come.
Let it be possible, my lord.
Let it be possible, my lord. If your lordship may.
At 2 p.m., my lord.
Not at 2 p.m. I will be taking original, sir.
Much grateful, my lord.
Passed over.
Much grateful.
Item number 29.
My lord, I am for the petitioner. This is my lord that petroleum respondents.
Indian Oil Company.
My lord, the added respondent at whose behest, my lord, my petroleum dealership was terminated. They had to, my lord, conclude their submissions. And I believe my friend appearing for the added respondent had requested for 10 more minutes to conclude, after which, my lord, we would give our reply. But I don't see him present today, my lord.
Short possible of the GPR is on a way.
Passed over. Passed. Let him complete today.
Item number 30.
As far as my communication goes, there's a proper settlement going on. I think after the patient, my lord.
Who is for the petitioner? কালকে কতগুলো ম্যাটার আছে গো? কালকে নট টুডে করে দেবো? ওর একটা ইয়ে আছে, নট টুডে করে দেবো। Not today. Come tomorrow. Let the petitioner come. Yes. Yes.
Item 29. 85. 85. 85.
Hey, Pritham.
I made the submission that completion of the tax both before the ICL, and now presently before your lordship. On behalf of by the new petition. And for this reason, only for this reason itself, the petition is liable. I don't take note. I have shown paragraph 7 to 10 and paragraph 21 of the petition. Judgments, my lord, I have placed my lord 99 for volume 2 SCC. For the meaning of and the effect of paper drafting. How the court should take note of that and how much deprecated. For that proposition, my lord, I have already shown 2008 volume 12 FCC 481. Now, well, paragraph 21 to 24. But with regard to the petition or the judgment, the petition, my lord, paragraph 7 to 10 and paragraph 21. And I say that all the documents were there. Now they are saying they signed some land documents, printed documents, they were never aware of. All these allegations were never made, never brought to notice of any court of law. And even today, those documents have never not been kept. My lord is aware that if I say there is a document in existence which has been manufactured by way of fraud and that document is maybe used against me, my first duty would be to institute a suit, apart from criminal proceeding, to institute a suit and seeking delivery of and cancellation of those documents. 2010 document, maybe he realized in 2014, maybe he realized in 2018, then in 2024. Till that it has not been checked. On the contrary, it is not in dispute that I made payment of money and he had received it. I have instituted a suit for recovery of that money. But I have disclosed the documents at page 40 of my affidavit in opposition. I'll show that. Now, madam, if your lordship kindly please take page 40 of my assistant document.
Yes.
This is the code I need to. I'm not troubling your lordship by reading the entire plaint, only a few relevant portion from there.
Yes.
Page 41, madam, kindly turn to page 41. Paragraph 2C. For the purpose of setting up a petrol pump, petroleum outlet, the defendant number 1 obtained financial assistance from State Bank of India. Having failed to keep the account of the bank standard form, the account had become irregular. For defendant number 1 also failed to repay the bank and also to the private individuals. He faced to it a situation where he had to abscond with his family members to avoid lenders' pressure. The defendant number 1 was in requirement of financial accommodation for a short period to ward off his temporary deficiency. Then, my lord, kindly turn to paragraph 4. Believing in the representation made by the defendants,
Yes.
believing in the representation made by the defendants, the plaintiff agreed to grant financial assistance to the defendant number 1 to the extent of 2.7 crore only. It was further agreed that the defendant number 1 would repay the amount lent at advance by the plaintiff in the manner under which the funds would be available with the defendant number 1 for repayment. However, the defendant number 1 undertook to repay the entire sum within a maximum period of 3 years. All the active participant of the defendant number of Ravindranath Pal, the defendant number 1 prepared certain documents, including agreement, a partnership deed, and a power of attorney. Each of the agreement, including the power of attorney, was executed on September 11, 2010 by the parties here. My lord, I have shown all these documents on the last day. During the period from September 2010 to March 1, 2011, the plaintiff, as per the instruction of the defendant number 1 from time to time, transferred funds to the plaintiff's bank account, personal account of the defendant number 1, being account number such and such, aggregating to 1.90 crore and all. having failed to repay the amount advanced by the plaintiff between the period September 2010 to March 2011, the defendant number 1 and Rabindranath Pal as an alternative suggested that the plaintiff might exercise his authority under the power of attorney and supervise the retail outlet business on behalf of the defendant number 1. Once again, believing in the representation of the defendants, the plaintiff supervised the business of the retail outlet. During the period from April 3rd, 2011 till March 2012, at the request of the defendant number 1, the plaintiff from time to time lent and advanced a quarter sum of rupees 99 lakhs and all. As such, as on March 2012, the plaintiff advanced an aggregate sum of rupees 2.90 crore. Though the plaintiff had agreed to lend and advance a maximum of 2.7 crore only, but at the instance of Rabindranath Pal, the defendant number 1, the plaintiff disbursed further fund, which was alleged to have been utilized for infrastructural development of the retail outlet and for purchase of a fuel tanker. During the period from April 2012 till November 2012, the plaintiff disbursed further sum of rupees 31 lakhs and odd. As such, as on November 7, 2012, the plaintiff had disbursed, lent and advanced to the defendant an aggregate sum of 3.21 crore. Has my The entirety of the sum was disbursed by the plaintiff to the defendant through RTGS or bank transfer, etc. In my lord, I have given the breakup. During the same period, for the purpose of surfacing entire floor area of the retail outlet, the defendant number 1 sought for disbursement of funds. The plaintiff had initially refused, but once again, at the intervention of the Rabindranath Pal, agreed to disburse the sum of 43 lakhs. That sum was disbursed in cash in this manner. Now, my lord, paragraph 11. As per the request of the defendant number 1, the plaintiff has been supervising the retail outlet. The whole proceeds of the same were deposited in the designated bank account, from which the drafts and subsequently through RTGS funds were transferred to Indian Oil Corporation towards the price of petroleum products and supplied to the retail outlet for. Expenses including payment of wages were also paid from the funds available in the bank account. This amount also remained in the account. The period of 3 years expired on September 10, 2013. Since the expiry of the period, the plaintiff called upon the defendant number 1 on repeated occasion to make payment of rupees such as 3.1 crore, only together with the applicable rate of interest. Defendant number 1 sought for extension of time to repay the amount lent and advanced by the plaintiff. Poetically, such period of extension was due for tomorrow. On October 2013, Rabindranath Pal fell seriously ill and was attacked by malignancy in his kidney. For his treatment, the plaintiff made substantial expenses. Taking advantage of the illness of Rabindranath Pal, the defendant number 1 started taking steps to alienate the plaintiff from the business of the retail outlet. Though the plaintiff had informed the defendant number 1 that several statutory licenses were required to be renewed, including the license of oil tanker, but no steps were taken by the defendant in terms thereof. Suspicion arose in the mind of the plaintiff, which prompted the plaintiff to hold a detailed discussion with the defendant. The plaintiff's utter shock and grief, the defendant had not only refused but started avoiding the plaintiff. Then, my lord, in these circumstances, a notice was issued. Then I was ousted for I and the staff which I engaged, my lord, paragraph 16 I have stated, they had been ousted from the business. Now, in the light of this, my lord, kindly please to take note of the written statement of it. And that is at page 56. Everything under the sun has been written. And it's simply a general denial. I'll show. Kindly take note, paragraph 17 once. For instance, the statements made in paragraph 1 of the plaint are false, irrelevant, misleading. It is false to state that the defendant number 2, Rabindranath Pal, has been a close friend of the plaintiff for over 30 years or at material point of time. Now, my lord, it goes on. And see paragraph 80. That the statements made in paragraph 2 of the plaint are false, concocted, purposive, illegal, misleading. It is false to state that in or about August 2010, the Rabindranath Paul came to the plaintiff along with Bholanath Das, the defendant number 1, or any person or represented as stated in paragraph 2 of the plaint, like that the defendant number 1 had been allotted a petroleum dealership by the Indian Oil Corporation in the year 2007, or that. So, it is also denied. Kindly see the standard of denial. I will not trouble your lordship by reading the entire statements, assertion. Now, all the paragraphs, my lord will be pleased to find that it has started like the statements made in paragraph such and such of the plaint is false, frivolous, manufactured, and malafide. It is false to state. Now, whatever has been stated in the plaint, that has been denied. So, everything has been denied generally without any specific assertion. Accordingly, my lord, presumption is to be drawn against it. Now, and they come to paragraph 46 onwards. Here in some last few paragraphs, we have stated, page 69, that 46. That your defendant number 1, Bholanath Das, begs to state that your defendant number 1 is a retail outlet dealer of Indian Oil Corporation Limited and runs a petrol pump at Ratulia under license number such and such, in the name and style of Ratulia filling station as the sole provider there, and has a retail outlet at plot number such and such, comprising of an area of 1 acre 20 decibel. Though he was a dealer of IBP previously, running his business of petroleum product in the same place, and afterwards the IBP company was merged with IOC. That for conducting his business, your defendant number 1 sought for financial assistance of SBI. The defendant number 1 took a loan of ₹1 crore. Unfortunately, the business of the defendant number 1 fell down at that period. That, as your defendants could not repay the aforesaid loan in due time, the loan amount along with the accrued interest became 1.30 crore, and as such, the SBI Tamluk branch declared the said loan account as declared NPA. That the SBI repeatedly demand and ask for your defendant to repay the said loan amount along with the accrued interest. Plaintiff is the owner and proprietor of a chit fund company under the name and style of MPS. The plaintiff and his employed agent collected a huge amount of public money from the people, in general assuring them a fabulous and attractive return within a short period of which any nationalized bank is or are unable to provide such type of handsome return. That the plaintiff anyhow came to know regarding the financial stringency and helplessness of the business of defendant number 1. That taking advantage of the sorrowful as well as miserable condition of the defendant number 1, the plaintiff, with a view to grab the business of the defendant number 1, approached the defendant number 1 that he helped the defendant number 1 personally by all means, including financially. That the defendant number 1 could not understand the evil motive of the plaintiff at that time, and as such he agreed with the proposal offered by the plaintiff. That the defendant number 1 begs to state that defendant number 1 never entered into any agreement with the plaintiff voluntarily.
Yes.
So agreement was entered into. Defendant number 1 signed on some stamp paper and some blank papers at the direction of the plaintiff without going through and without understanding the purpose of the contents of those so-called deeds. Signature is admitted.
Only that it was not voluntarily done.
That is his step. I am taking money from someone. I am executing some documents. And later, standard practice where the bank loan cases, whenever some borrower, no bank made me sign all those documents. Now, But I'll not trouble you or waste your lordship's time by taking submission on this. That at the time of supervision of the pump, the plaintiff also did monetary transaction and the defendant number 1 signed at the direction of the plaintiff without understanding his motive. That the plaintiff purchased handsome quantity of land in his name in the vicinity of the petrol pump from the income of the petrol pump. That those lands was or were cultivable land, the plaintiff converted to those lands into highland and at the cost of the defendant number 1.
Yes.
That those lands of the plaintiff afterwards were surrounded by pakka boundary walls of much height at the cost of the defendant number 1.
Yes.
That the plaintiff transferred some money time to time in the account of your defendant, but after transferring those money, the plaintiff directed your defendant number 1 over phone to make payment of his labor's worker, and accordingly your defendant number 1 paid the cost of materials and wages of the worker of the plaintiff, sometimes in cash, sometimes by check. In fact, those money which were transferred to the account of your defendant number 1 has or have been used for the purpose of development of the land of the plaintiff. That the plaintiff is not entitled to the reliefs as prayed for, suit is liable to be dismissed. I do not find any counter. Now, this case, I made some payment, maybe say 100 rupees, and 100 rupees has been incurred by them for my benefit. So whether I am entitled to money or not, my lord, that I take care of it. But while receiving that 100 rupees, he executed some documents which were not done for him. And execution part is not done. That's the best case of the petitioner hearing. That is the difference. Now, my lord, I propose this the case I have made out in the plate. I mean, made out by my father, who actually was a fire later. Now, my lord, I launched a complaint before the IOCA, which my lord may be pleased to find annexure annexure to the affidavit in opposition by IOC. Annexure R1, that is at page 30 of affidavit in opposition by IOC.
What is this document?
This is the content of the basis whereas this was illustrated and ultimately the decision.
What is the page number of that complaint? In the writ petition?
It's in opposition of IOC. Their case is that they were not provided with this document. IOC has discussed.
What is this date of this opposition is? 23rd July 2021.
Yes.
Page 30. Yes. Huh.
Now, why not Paragraph 1. As per agreement dated 5th December 2007, one Bholanath Das, such and such, was given license, have got the license in favor of Ratulia filling station to run a petrol pump.
Yes.
Now, paragraph 2 and 3, my lord, I am not repeating again. I have stated that how the money was flown from my father to, in favor of the writ petitioner. Paragraph 2 and 3. My lord, in 5th line, my lord, may you please find the reference to 3.85 crore. Paragraph 4. Not only in order to do this business smoothly without facing any unnecessary hazards or legal complications in the Bholanath Das executed a said general power of attorney in favor of my father. Moreover, a partnership deed was executed between both of them for the purpose of determining the mode of profit sharing. All this was done for the purpose of smooth refund of the money given by my father to Bholanath Das. 5. It is pertinent to mention here that both of them had opened a joint account to operate the business smoothly in the name of Ratulia filling station, with account number such and such. Since the beginning of 2014, no problem arose. But suddenly my father received a letter from the appropriate man concerned, dated such and such, literally informing about the direction of his name from the said joint account by the Bholanath Das. Deletion of his name from the said joint account. On the next day, it was found that the staff of the Ratulia filling station appointed by my father had been kicked out and possession of the pump has been taken forcefully by the said Bholanath Das, accompanied by his men and agent. Further, after deleting the name of my father, the said Bholanath Das has misappropriated the balance, rest of the money, that is rupees 24 lakhs and all, and ultimately stopped running the business, of the state pump. The joint account, photocopy of the joint account, or whichever was available to me, that was also disclosed, provided to IOC. Must be lying there. Paragraph 8. Finding no other alternative, my father instituted a money suit. Being AS numbers, the number is incorrect. It should be 14 of 2014. AS 14 of 2014 before the direct civil judge for recovery of 3.85 crore. Then was also discovered. It is worthwhile to mention that subsequently it has been discovered that Bholanath Das did not obtain any prior permission from him to receive the said investment from my father and the documents which he produced at the point of time he is absolutely forced to. Presently, from reliable source, I have information that the Bholanath Das is going to commit such kind of project as well as power and criminal breach of trust with some other person. It is hereby noted that at present, due to some legal turmoil, my father, Mr. Marla, is in custody of CBI. Further to inform that CBI had already taken note of the aforesaid incidents and started investigation thereof. Therefore, under compelling circumstances, I, the undersigned, into legal areas of conduct, we hereby requesting your good self to take appropriate steps so that further complications cannot arise in this regard by cheating or any third party interest. Further, you are requested to suspend or report the same license without any inordinate delay for the purpose of proper adjudication of the pending litigation before the direct court as well as before the CBI authority. This was the sum and substance of my complaint. Now, if I have correctly understood my learned friend's submission, one decision was taken by someone who himself conducted the inquiry. My lord, I am candidly speaking, I am not making any submission in that regard. That has already been replied, thoroughly submitted by Mr. Vasula here. 2. The complaint was kept in abeyance for say 2.5 years or 3 years. I am putting this question to myself, my lord, whether it went to his benefit or detriment. It cannot be said to be, in fact, during those 3 years, he could run the business and would make the profit out of that. So it would not go in his detriment. So, and whether this could be said to be acquiescence or not, but I have shown the meaning of acquiescence. It cannot be said to be an acquiescence on the part of IOCL because acquiescence has to be a positive. It cannot be by implication or he was made to sign on blank papers. But I have tried to satisfy your lordship. Those documents have never been challenged by him, despite a period of around 14 years has passed. So those documents are prevalent, even not in the system. So
Yes.
he was not given given the right of cross-examination, cross-examining the complex. The situation is that the IOCL never asked me and never examined. I have examined the question of cross-examination never arrived. Now, to my understanding, everything is documented. IOCL went on the basis of the document and the assertion made by the repetition. IOCL even gave him the opportunity to say sorry, that I'll never do it again, and so that it could be restored. He also did not opt for that. So it is now between IOCL and the institution of whether IOCL had proceeded correctly or not. My lord will be adjudicating. I am only on the part which was not before your lordship. In fact, when the petition was filed, I was never included as a party. Only at the time of the final hearing, at that stage, my lord's coordinated bench was pleased to find that the complainant being me has not been made party. So accordingly, after the direction of the honorable court, I was made a party.
Yes.
So at every point of time, there has been consistent endeavor to suppress the original fact. My lord has been pleased to direct me the assertion from my affidavit. My lord, now, only thing that troubled my mind, and I should bring it to your lordship's notice, is the case of section 14, subsections 1, earlier clause C and now clause D of the specific relief act. 14(1) এখন D হবে 14(1) D of the specific relief act.
Which case?
The repetition. Termination in a determinable contract. Clause 45 has already been placed before your lordship that it's a determinable contract. Now, if a determinable contract has been terminated, whether he is entitled to restoration or even if the termination is held to be illegal, then he is simply entitled to compensation subject to section 30.
এখানে হবে কিনা?
May I read for your lordship?
না না বার করে নি। Specific relief act?
Section. Which?
এখানে কম্পিউটার কি আছে পেয়েছো এটা দাও তো ওয়াইফাই এই না Let's wait for some time. Yes, 14.
The following the contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely A, B, C, my lord, I'm skipping for the time. My lord, D, a contract, the performance of which involves a performance of a involves the performance of a continuous duty which the court cannot supervise. And C, a contract which is in its nature determinable. Now, if a contract is determinable, right, the next case is that it is not, it cannot be determined. In this case, it has been determined in a manner which is not provided in the contract or otherwise it is now, if a contract is a determinable one, then my lord, the Supreme Court in the case of Amritsar Gas Services reported in 1991, volume 1 SCC, page 533. My lord took the view then that his remedy lies in compensation.
1991 volume.
1991, volume 1, SCC, page 533. I am relying on paragraph 12 to 14, 1-4.
You have a copy? Or else you read it from there. Let's find out. You both spoken. Yes.
My lord, in this case, an arbitration proceeding was held, termination, arbitral challenged in arbitration proceeding was held. The award of the arbitrator was under challenge in section 34. Ultimately, parties went up to Supreme Court. Now, before that, my lord, paragraph 8. Got the arbitrator in his award has held that the applicant corporation committed breach of contract, and on that basis, it has been held to remedy the breach by restoration of distributorship and pay compensation for the reasons given in the award. The counterclaim made by the appellant corporation in the written statement was not decided by the arbitrator on the ground that it did not come within the scope of the reference. Respondent number 1 has filed an application to direct the arbitrator to file the award and then to make the
Yes.
and then to make the award a rule of the court and to pass a decree in terms thereof. Appellant Corporation, however, filed objections under Section 30 of the Arbitration Act. It is the CMP of the and the objection therein, which are to be decided by us. The arguments advanced by Shri Salve on behalf of the Appellant Corporation to the validity of the award are these. The first contention is that the validity of the award has to be based on the principles of the private law and the law of contracts, and not to the touchstone of the constitutional limitations to which the Indian Oil Corporation as an instrumentality of the state may be subjected. Since the suit was based on breach of contract alone, and the arbitrator also proceeded only on that basis to grant the relief. It's urged for the reason the further question of public law do not arise on the facts of the present case. The next question is that the relief of restoration of the contract granted by the arbitrator is contrary to law, being against the express prohibition in section 14 and 16 of the Securities Act. It is urged that the contract, being admittedly revocable at the instance of either party in accordance with clause 28 of the agreement, the only relief which can be granted on the finding of breach of contract by the appellant corporation is damages for the notice period of 30 days and no more. It was then urged that the reasons given in the award for granting the relief of restoration of the distributorship are untenable, being contrary to law. Shri Salve contended that the propositions of law indicated in the award and applied for granting the stability an error of law apparent on the face of the award. It was also urged that the onus of proving the valid termination of the contract was wrongly placed by the arbitrator on the appellant corporation instead of requesting the plaintiff corporate respondent, number one, to prove the termination was invalid. It was also contended that the failure of the arbitrator to consider and decide the appellant corporation's counterclaim when the whole suit was referred for decision constitute a legal misconduct. Now, my lord, I am not going into the legal misconduct part, that is purely arbitration issue. Now, whether I am purely on this section 14 and section 16 issue of the specific relief act, terminable contract, whether it could be termination thereof, could, even if it is held illegal or in breach of the contract, would restore the position. Now, my lord, paragraph 11 onwards. 11, section 11 is article 14 of the Constitution. 12. The arbitrator recorded finding on issue number 1 and termination of the distributorship by the appellant corporation was not validly made under clause 27. Thereafter, he proceeded to record the finding on issue number 2 relating to grant of relief and held that the plaintiff respondent number 1 was entitled to compensation flowing from the breach of contract till the breach was remedied by restoration of distributorship. Restoration of distributorship was granted in view of the peculiar facts of the case, on the basis of which it was treated to be an exceptional case for the reason given. The reasons given in the reasons given state that the distributorship agreement was for an indefinite period till terminated in accordance with the terms of the agreement, and therefore the plaintiff respondent was entitled to continuance of the distributorship till it was terminated in accordance with the agreed term. The award further says as under. This finding, along with the reasons given in the award, clearly accepts that the distributorship could be terminated in accordance with the terms of the agreement dated 1976, which contains the aforesaid clause 27 and 28. Having said so, in the award itself, it is obvious that the arbitrator held that the distributorship to be revocable in accordance with clause 27 and 28 of the agreement. It is in this sense that the award describes the distributorship agreement as one for an indefinite period that is still terminated in accordance with clause 27 and 28. The finding in the award being that the distributorship agreement was revocable and the same being admittedly for rendering the personal service, the relevant provisions of the Specific Relief Act were automatically attracted. Subsection 1 of Section 14 of the Specific Relief Act specifies that the contract which cannot be specifically enforced, one of which is a contract which in the nature of determinant. In the present case, it is not necessary to refer to other clauses of subsection 1 of Section 14, which also may be attracted in the present case, since clause C clearly applies on the finding read with the reasons giving in the award itself that the contract by in its nature determinable. This being so, granting the relief of restoration to the distributorship even on the finding that the breach was committed by the appellant corporation is contrary to the mandate of Section 14(1) of the Specific Relief Act, and there is an error apparent on the face of the award which is stated to be made according to the law governing such cases. The grant of this relief in this award cannot therefore be sustained. Oh, my lord, I'm not going into the other release, the counterclaim, etc. So, my lord have already been pleased to take note of clause 45, that is the termination clause. It is nobody's case that a contract could not be terminated. If it has to be terminated, petition also says if it has to be terminated, it has to be terminated in accordance with the contract and in accordance with law. Nobody can say that it has beyond law. Now, even if it's the contract has been terminated beyond the terms of the contract, since the contract is a terminable one, then his remedy lies in compensation and damages. If he asks for and can prove that. And that's not in a repetition, but in a suit or arbitration, whichever is. My duty was only to show to your lordship the documents which were there, the facts which were there, and those have been suppressed. And the law, my lord, my little acumen, my lord, I thought that this law should be brought to your lordship.
Can you just refer to the agreement between the IOCL and the petition, clause 45? Will the position of law stands the same if you come to page 541 of the judgment referred? The position of law stands the same. Here, see, it is urged that the contract being admittedly revocable at the instance of either of the parties. Here is a contract which is determinable. I mean, the IOCL has the liberty on certain conditions to revoke the agreement. But the agreement which is depicted in the judgment you have referred, that is that either of the parties can walk out of that particular. The law stands the same if it is determinable at the instance of one of the parties and determinable at the instance of either of the parties.
It's absolutely a pertinent question whether, and I should reply to that. In fact, I have not checked whether I mean, the writ petitioner could terminate or not.
Petition withdraw from the agreement or not. Huh. Yeah. Yes, next.
Common substance of my submission. The proceeding jurisdiction. A person can seek equity if he comes to only two answers that I need to satisfy your lordship, whether the petitioner could at the same time he had the right to determine the contract or could withdraw from the agreement. That I have to find out from the agreement and with regard to the question of separation, whether I have pleaded, paragraph 2 itself also probably
Two of
my opposition. But paragraph 2, the present product is a responsible and is an abuse of forms of law. Petition suffers from sub-ratio value and suggestion. And thereafter, I have pleaded what had happened, what documents have been executed, and so far my knowledge is concerned, no reply to this has been received by me at least.
There was a direction from the Supreme Court for expeditious hearing.
Very
So,
well.
my lord,
Very well. Supreme Court.
we had prayed that since we are not putting in a reply, none of the allegations would be deemed admitted, and we'll proceed on the basis on that basis for the argument.
Let this observation of the Supreme Court that none of the allegations.
No, there's no observation, my lord. This is my submission, which I had also, my lord, at the time when the hearing was commencing.
Assertion on affidavit could be replied only on oath and not from the bar. We can only argue, we can only interpret, we can only show the law, but the facts has to come. The facts to be stated by the clients only, litigants only. I have categorically stated no reply to this.
Hundreds of orders.
Aware of specific solutions of the case.
Well, in writ juris, hundreds of orders pass day in, day out. That since affidavits are not called for, or since an affidavit is not being filed, to that limited extent, the court.
We are in hearing stage. Those are in motion stage.
If I don't have anything.
Mr. Lahanan, please hold your breath. I will going to complete only within 2-3 minutes.
Yes.
But those are in motion stage. Court finds to give the remedy to the parties. Court says that since no affidavit has been called for, here parties had the opportunity. I made specific allegation. Not for a single day, a single request has been made to the court to file their reply to that, to controvert it. And whatever I have stated here, that have been stated in the plaint as well, mostly I have shown your lordship. And what best reply could be given by the petitioner here, that could be seen from the written statement in that suit.
Yes.
So my next separation I have shown, and only we'll just check and show the list, or in the at the highest, if your lordship finds that there were irregularity, only a condition of the part, then at the highest you could get a further fresh proceeding. But that will not, that can never give him the remedy what he has got for him.
So there has to be a fresh agreement.
At the highest, if your lordship is not satisfied with the proceeding or the tenor of the proceeding, then sometimes in rarest of cases where courts allow fresh adjudication.
As per your submission of the best and get a best adjudication
from IOC.
To decide on the.
But my clear dismissal of it.
Okay. The records, the records of the proceedings, since he has taken a plea that the person who prosecuted, he passed the order, and it was submitted from the side of the IOCL, that the process is that the prosecuting officer sends it to the higher authority who passes the order. It is not the case that the prosecuting officer has passed the order. So, with regard to the proceedings that were initiated, I need those records to be produced before this court to check that. Produce that record. Thereafter, you peruse the records and make your replies to that. Mr. Mukherjee, you have concluded.
I am not getting into that.
One thing which baffles me is that a third party who is not even a signatory to the contract is trying to give my lord evidence to interpret what the parties to the contract would have thought or would have perceived when the contract.
I have been given the liberty. I was avoided. I was not implemented at all. The honorable court directed to implement me. That order was never challenged.
Sure.
So,
And Mr. Saurabh Mukherjee, learned advocate for added respondent number 7, who concludes his argument. Mr. Lakhani, Rachit Lakhani, learned advocate appearing for the petitioner, seeks accommodation to place his replies. Learned advocate representing IOCL respondent numbers 1 to 6 is directed to produce the records of the proceedings. Being number, what was the number of the proceedings? Yes. Produce
The subject was order 116 and it's proceeding related to the tabulation of the directive.
Here is a reference number in the right hand corner. This is not the number. Proceedings in respect of termination of dealership license of the petitioner. Pursuant to so-called notice under reference number HDO, HD, Delhi, HDO/SCN/RFS dated 26th July 2018. It is at page 109. কবে হবে প্রীতম বাবু? 14th. मंगलवार ये नहीं तो 14 January मिस्टर लखानी 14 January
Yes.
huh? No. Huh? But there will be other matters also. It will come later. That will be the difficult. তো কবে যেতে পারে দেখো ফাঁকা দেখে দাও 7th লাগানি
7th. I'm there every day.
I was just asking Mr. Mukherjee. Everybody has to be there, not only you.
At my stage, my lord, we can't afford to miss court a single.
We have to make our six.
No, not miss the court, but there might be some other other appearances outside.
7th, my lord, is convenient.
On 7th, huh?
Grateful, my lord. Yes.
Lordship,
কি হয়েছে দেখো তো ওখানে
28 is concerned, Madam Lordship. Lordship kindly accommodate, my lord, me, my lord.
You just tell me when can this be produced. I will fix that date.
No, I can, my lord. Lordship kindly affirm my evidence, stating all the facts, why it has not been done, what has that has to be, my lord.
my lord, that thing, my lord, and report. In the report, everything has been detailed, my lord. It is with your lordship's record.
No, I
Lordship, it is everything. It has been dealt.
This is, I am not serving him. He knows everything.
My lord,
that
in the report, my lord, everything has been dealt, and my lord, annexure on the last occasion, which they were saying that they want to include in.
to file affidavit.
And on the last occasion, my learned senior friend was mentioning one date of the letter. They were saying that they want to include in the record. That is already in the report, annexure A of the report. Kindly seize, my lord. Kindly seize their affidavit report, annexure A. My lord, everything has been dealt in the report. Then in the report, what they have said, my lord. From the last 4 occasions, they are saying that they will produce the possession certificate. Again, they are alleging all the arguments, pleadings, my lord, that has already been dealt in the report which has been filed by my learned senior friend.
Going to, my lord, dispose of the writ petition. That is why, my lord, I have to.
That has everything has been considered from the last 4 orders. From the last 4 orders, everything has been considered. And finally,
Today it is being affirmed, my lord, can fix anything.
kindly seize all the 4 orders lordship has passed, pleased to pass. Everything has been dealt in the report also, my lord. The reasoned order passed by the concerned authority, and after that they have produced the impugned reasoned order we have challenged through this writ application. Then they have produced the report in the form of affidavit. Everything has been dealt in detailed in the report, my lord. Then everything heard, and then lordship was pleased to direct to produce the possession certificate.
From the very beginning, you are representing the state.
Lordship.
On May 2024, Mr. Pantu Devrai appeared for the state. Yes. What is your submissions come to this order? On May 2024, you have submitted that the possession of the particular premises was handed over, despite they have failed to raise construction within the stipulated period. That is the only case. If they have, in spite of getting the possession, they have failed to, then they have no case. Now, the next paragraph says that learned counsel seeks to produce possession certificate by way of an affidavit. Now, you make an submissions, and thereafter you change and say that we will be filing a supplementary affidavit. Why? Upon your submission, there was a direction to produce the possession certificate. If the possession certificate, sir, please. If the possession certificate at that point of time was not with the state, it could have well been submitted before the court that we do not possess that possession certificate. Upon your submission, the direction has been issued. Now you do not comply the order of the court. That is the only crux of the matter. If the possession of the land is given, and within the stipulated period the construction had not been raised as per the lease deed, then they have no case. If the possession is not delivered, then they have a case. This is what on the previous occasion I also stated to you, produce the possession certificate. What is preventing the state from producing that? Yes, yes, you speak. Yes, yes.
Anger, that is the.
No, no, not anger. I'm just asking you. This is a submissions which was advanced.
They asked to produce, asked to get the possession, but he failed to do this. He did not turn up. He has to come to the particular place where he possesses. Then, my lord, the concerned authority issued certificate. This is the process. Initially, I did not submit this thing. After coming to learn, this thing is this is not the video is not affirmed. Lordship can go through the clear.
Why?
Lord, if it is my learned senior friend submission that
Request to fix a date for physical possession plot on either by has the assistant estate manager Kollani issued any letter to the petitioner?
Lordship. After that,
where is that letter?
Annexure A, my lord. Annexure A of the report. Annexure A.
Asking the original allotees के notification for Srimati Chebali for एक बार position of the subject land by 15th October 1997. But in that case, my lord, they failed to do so. Well, even after 30 years, they did not know, authority did not know about their demise or not. And they failed to, my lord, executed the listing.
Did the assistant estate manager Kalyani issued any letter
Lordship.
to the petitioner?
Yes. 15th October 1987.
15?
September. The 10th September 1987, Annexure A. And after that, my letter.
Wait. On the last date, you have produced a letter dated 10 September.
Lordship.
10 September 1987.
This letter was not forwarded to the petitioners. It was forwarded to the assistant estate manager Kollani, asking him to fix a date for physical possession of the
Lordship.
plot. On
Yes. They kept it on the date of the original allocation. And it was only July 1999. July 99, he informed the authority that yes, the Lolit Mohan Kaur and Sepali Kaur has died.
arrange for on approach either by
Lordship, may I intervene?
before fixing a date is
My lord, Annexure A.
Yes.
Annexure A is the letter.
So this notice.
They have directed to pay the entire amount and take the possession. Annexure A of the report. And to that report, my lord, we have given the
File the affidavit. We'll see. What is this affidavit? File done. Give a copy. What is this affidavit about?
Lordship. My lordship, they have taken the
Additional affidavit. Additional affidavit.
Mr. Pantu Dev Roy, London Advocate for State Respondents, files affidavit. The date is wrong. ও অ্যাফার্ম করবে 6 accommodation, correct the date, it's not 6th May, it is 16th May. 6 extension of 6 leave to file supplementary affidavit in compliance to order dated 16th May 2024. Leave granted. Let such supplementary affidavit be filed within a week on reopening of court after winter vacation. The reply thereto, if any, be filed within a week thereafter. Leaves this matter after 2 weeks on reopening of the court after winter vacation. আর কোনটা আছে পাসওভার? আর কোনো নেই তো পাসওভার? আর পাসওভার নেই তো? হ্যাঁ, নেক্সট যাবো।
Item number 31 and 32.
32 I was yes, I have filed my
30. 31. 31, 30. 30? 30 তো not today হয়েছে। কারা নিয়েছে?
30? Mr. Roy? You are for 30?
I am for the petition.
I am for the private respondent.
Who appeared for the private respondent? No, not you. There was some advocate who appeared for. আচ্ছা ঠিক আছে, না বলে দিন। Mr. Roy, somebody appeared for the private respondent, junior advocate. Since the petitioner was not there in 30, since the petitioner was not there, আমি কি করলাম ওটা? Not today. Tomorrow it will come up. আর না হলে এটাকে কেটে দেন, কি বলছে দেখি। What is?
Parties are here. There is no dispute regarding.
My lord, I am the petitioner in this case.
Item 30.
This is a case, my lord, for unauthorized construction of the building.
But what happened to the temple? What will happen to the temple?
Sir, my lord, your lordship.
One matter I want to submit before your lordship. This is not a matter of how my learned friend is acting. 20 square feet is a temple. Now, my lord, under the provision of the Howrah Municipal Corporation Act 1977, subsection 1, 2017, the commission has the power not to regularize at the minor. A 20 square feet building, not a temple. My learned friend is a person who is a club.
Well, one of the co-sharer.
Eviction degree passed.
No, my lord, one case is pending, my lord.
Eviction
Undivided property,
degree.
everything
Execution
is
has
there.
been effected.
My lord.
Execution has been effected.
My lord,
Now
they have filed a
is
suit.
just to keep these persons somehow to be busy in the property. So 20 square feet at best, my lord, in their report also. My lord, can you consider whether the writ application is based on this plot? Never. Subsequently, my lord, it was incorporated by way of oral submission and on the basis of the report. This 20 square feet temple is. So even if my lord, can you consider whether this 20 feet temple can be considered for the commissioner? If the commission is the opinion that it can be regularized under 177(1), subsection 1, commission can pass that order, revision should be, or commission can pass the necessary order for demolition of the same. Keeping this matter pending, my lord, what they are doing, my lord, practically they are now disturbing my position for the property. It's club.
What is the prayer in the writ petition?
Yes, my lord. Can I turn to
My lord, your lordship kindly come to their own, my lord, suit, they have filed before the lower court. That is the suit for declaration and injunction. They have suppressed this fact. When I filed the writ petition before this honorable court, stating that they have raised an unauthorized construction over an undivided property. In the meantime, my lord, they appear, they file opposition. Prior to that, my lord, they filed a suit before the my lord, civil court below for declaration and injunction. That they have not, my lord, at all disclosed in their, my lord, affidavit in opposition, which I have stated in my own affidavit in reply. My lord, your lordship, come to my affidavit in reply, I have stated it. And where they have claimed before the lower court below that the suit for declaration and injunction, they are claiming that they are also one of the co-sharer. And also we are also one of the co-sharer. The case is still pending, which they are not stated in their own opposition. I have stated in my own reply. So, my lord, they are saying we have suppressed, already they have suppressed their own fact. The case is still pending. 176(9) of 2023. Page 64. of my reply. Page 64 of my reply.
Now can turn text of the writ application once.
Page 64 of my reply, my lord.
Yes, I'll bring each and every. And it takes up the writ application, my lord. Can you consider what was the subject matter of dispute? Page 6. Page 5. Subparagraph 6. The petitioner states that the private respondent were practicing fraud upon the court. The lower court, my lord, got it.
Paragraph 6.
Yes, my lord.
Ah.
Adopted an expert degree entitled to 140 of 1988. By exposing them absolute owners of this rest of the suit property, having not disclosed the property as undivided and co-share property, challenging the said expert degree partisan suit has been filed by Srimati Sujata Maji as well as the petitioner Ichapur Chandrimata Club. Hearing such and such, which the suit has been awaiting for decision in the pending appeal to the Honorable High Court, being such and such. And during admission of the said appeal, Honorable High Court passed this order internally as follows. No matter the order has been quoted. And what is the fate of this appeal? I'll draw it to your lordship subsequently.
What was the suit filed, title suit 141 of 1988?
For recovery of possession
By the private respondent.
by the private respondent against the club
Okay.
and others.
Others means who?
The club and another name has been mentioned, my lord. If your lordship can consider Sujata Maji,
Who is Sujata Maji?
one of the
One of the co-share. My lord, I have annexed the RS record of right.
My lord is not considering the title of the parties so far. by-
RS record
No,
of
no,
right.
I'm just concerned about what is the suit
Yes, my
about.
lord, suit for. If your
So
lordship
this is
can-
against Chondi Mata Club and Sujata Maji.
Yes. Now, my lord, can you consider what is the prayer made? Paragraph 8. If your lordship can you consider paragraph 8.
Yes.
The petitioner states in respect of the A schedule property of this said suit, private respondents have got possession by execution of the degree. But both the doc number 448 and 448 161 are integral and inalienable part of the property, and it is still lying undivided and demarcated with the joint co-share property. What they tried to say, my lord, this was 448 was the subject matter of dispute.
448.
Yes, 448 by 1331 is another plot. They said it is amalgamated, so no partition can be effected, and the degree, be as it may, is not executable also. But the degree has been executed and everything has been done. Private respondent getting the law in their own and under the guise of influence and the unseen power, having proposed them an order that will started construction of mandir as well as building attached to the said mandir on the disputed land without any sanction plans. So therefore, my lord, this thing has been done after the execution. From the writ application, my lord, it appears. The petitioner says the private respondent getting the law in own hand under the guise and influence of the unseen power, having poised with them and an order of the day, have started construction of the mandir as well as building attached with the said mandir on the said land without any sanction plan from the competent authority, and day and night with their repair work force, they are trying to complete the said construction hurriedly in violation of the Howrah Municipal Corporation building rules and an act thereon. And my lord, can you consider the next, my lord? They are sharing the said property and they are one of the co-sharers. And a representation was made on 17th April 2023.
Yes.
Now, my lord, can you turn to page 16 once, my lord? Was the donor, my lord, Sushma Datta, Swami Ishwar Madan Mohan Dal. My lord, got it?
Yes.
To whom it has been transferred, my lord? If your lordship can turn to Rohita. Oh, yes. Page 14, my lord. Can you consider Ichapur Chondimata Club? My lord, got page 14, my lord, if your lordship can. Now, my lord, the first representation, my lord, will find in the year 2023. That your lordship will find at page 42. Retribution.
Page
Page 42, my lord, got it. 42 and it's a P7. This is the first complaint for the authority concerned alleging the unauthorized construction over the plots in question. What are the plots, my lord, will find? Page 43, first paragraph. These are the two plots.
Yes.
Now raising an unauthorized and illegal construction on plot number 448 by 1311 being an integral and intangible part and portion of plot number 448.
Yes.
So this is the specific statement made in the representation. Construction is going on in respect of plot number 448 by 13311, which is the subject matter integral part of 448. But the construction is going on that subplot. Now, man, can you consider, can you test up for the plainer or opposition once?
By 567.
Opposition of 567. I am drawing a lot of attention to page 10. এটা কি টাইটেল শুটে মন্ডলের স্তম্ভত্ব কি ওর মদন কি my lord, can you turn to page 10, my lord, got it? This is the degree of the suit. Where?
My lord, your lordship, kindly come to page 11, my lord. Better. The plaintiff
Let me
case
place
is
my
that-
case. After that,
The plaintiff case in short is that plaintiff
Yes.
is the co-owners and possessor of comprising that number 448 and 449 by 539. Co-owners.
I am drawing the attention of the court, so it is my duty
That is
to
the
point
degree.
out.
That is the degree.
Yes, no, that is not the degree, probably subject to correction. Now, my lord, can you turn to
Order, sorry.
page 19? Defendant's legal status has not been proved. My lord, got it? Page 19, the operating portion, my lord, because
Yes.
defendant's legal status has not been proved in any way. On the contrary, the plaintiffs are able to prove their right title interest over the property in suit. Considering all the above aspects, I am inclined to decide this issue in favor of the plaintiff. According to the plaintiffs are able to prove their case and it stands. The suit same is decreed on contest against the defendant. Even is directed to vacate the suit property within 90 days from the date of this order. Now, my lord, can you turn to the schedule? What is the schedule? That your lordship find page 22.
Yes.
My lord, can you consider the schedule page 22?
448.
What is the schedule? 448. It is not in what they are doing as if this 440, that Bata plot and the plot that has been, Bata has been executed, the plot has been demarcated and execution has been done, satisfaction recorded, that this property has executed in my favor. 448.
But what were 448 by 113?
That is there. That is distinct.
That is also there.
That is distinct. Now the commission, Authority should come and allegation is, my lord, in the butter plot it is construction is going on. Now the corporation should come up and say, yes, this is the plot upon which this construction was going on. These two distinct plot.
Your lordship, kindly page number
Let
46, my
me
lord.
finish. After that, you have the kindly turn to page 25, the execution case. হ্যাঁ, এটা আগে দাঁড়াও, দাঁড়াও, আবার দাঁড়াও। 47. My lord, kindly consider who have page 25, my lord, got it? Who have filed this 47? The Doni.
Yes. I mean the defendant.
Yes. Steps into the shoes of the defendant.
Who is Chandranath Datta and Sudhanna Datta?
From whom we are deriving title.
Okay. Chandranath has transferred this, gifted the property in favor of Ichapur.
Bhuvan Chandra, my lord, that is my lord, Amol Chandra Datta.
Amol
Amol Chandra Datta, thereafter, my lord, their sons have gifted the property to my lord.
Mr. Roy, you means you, what is the name of your client?
My lord, he is from Bhuvan Chandra Datta.
Bhuvan.
Yeah, Bhuvan Chandra Datta, my lord, your lordship kindly come to page number 46, my lord, I will, my lord, precise the fact. Your lordship kindly come to page
Yes,
number
Mr. Roy.
Yes, my lord.
46.
Our is yeah, Madhav Datta.
Madhav.
Mahadev Datta.
Mahadev.
Mahadev.
Mahadev, how he is related to Chandranath?
My lord, if your lordship can turn to page 27, your lordship find.
Yes.
That the suit dag, my lord, according to the opposite party, belongs to Nobin Chandra Datta and Ramchandra Datta. Thereafter, Nobin Chandra living behind his son Bhuvan Datta, my lord, got it. Page 28 from the top I am reading.
According to opposite party, yes.
Yes. Thereafter, the Nobin Chandra Datta died leaving behind his sons Bhuvan Datta, Tulsi Charan Datta, Kanu Charan Datta. Subsequently, Tulsi Charan Datta died leaving behind his only son Amulya Charan Datta. Kanu Charan Datta died leaving behind his wife Yashodamoyi Dashi. Bhuvan Chandra Datta, Amulya Charan Datta, Yashodamoyi Devi were recorded CS record of rights. Ramchandra Datta also died leaving behind his 5 sons. The plaintiffs, my lord, got it. Now the plaintiffs is coming, my lord. Mahadev Chandra Datta, from whom we are
Yes.
deriving title. So this is the fact for our. Now, my lord, kindly consider what this Tanner Executive Court held, my lord. If your lordship kindly turn to page 35. Both the execution case and the bis case was taken up for consideration. In such circumstances, my lord got it from the middle portion. It is clear that neither Madan Mohan Datta or his legal heirs any right, title, interest in either Dag number 448 or Dag number 448 by 1331. Thus, the Exhibit 7 deed of gift executed by legal heirs of the Madan Mohan Datta in favor of the petitioner club is not valid document of transfer, and such petitioner club has not got no right and interest in the property transferred by the said invalid deed of gift in its favor. As a result, the petitioner club did not derive any title to the either Dag number such and such. Therefore, there cannot be any question of the petitioner club became the co-sharer either in 2 Dags. But there is no bar in proceed with the execution case filed by the opposite party, degree holders, and the degree passes can be executed properly.
So identification has been considered. 47 rejected by holding. They have no subsisting right and interest over the property because what they are, from whom they are claiming is no right, has no right and interest. Now, my lord, can you turn to page 40? This order was challenged.
Wait.
Page 40.
This section 47 is a execution case arising out of title suit 199 of. Huh?
And it was held that the execution can be proceeded with. Therefore, 47 has been rejected. Now, challenging that order, my lord, can turn to page 40.
Can you just explain that in such circumstances, if Madan Mohan Datta or his legal heirs do not have any right in dag number 448 and 448 by 1311.
Yes, we are the Mahadev Chandra Datta, my lord.
Oh, yes. Madan Mohan is okay, correct.
Oh,
Madan,
okay.
okay. Yes.
Now, I can turn to page 40. This order was subject to challenge before this honorable court.
Oh.
At the instance of the club.
That is the gift deed executed by Madan Mohan.
Yes.
In favor of the.
In favor of the club. Which I have shown to your lordship.
So 47 goes, their rights are not established. Since
Now,
they have no right, so club cannot derive any right from them. Correct.
turn to page 40. That order was challenged before this honorable court. (44) is the relevant portion.
Yes.
Accordingly, this revision application has been dismissed or contest and further request to dispose of the pending execution title execution case number such and such. So it was upheld up to this honorable court. Then, my lord, this 9/11/23 comes. It was written by Mike. The demolition wall already been demolished by the authority.
Who is this person? 9/11/2023. Who has written this letter?
It is our learned advocate on record. To the assistant engineer in the absence of any order of demolition, he have came and wanted to demolish. So it is only for the purpose that battery is pending, so you should not continue the demolition work. Because it may, my lord, if there is illegal construction, there is no order of injunction, they have every authority to demolish the wall. They have demolished. Now, I'll kindly turn to page 46.
Surely.
Page 46, your lordship find this appeal was preferred.
Against that, which order?
Against the original order passed in the suit. After 47 goes, my lord, that chapter goes. Now the parent order comes into play.
My lord, this is for, my lord, suit for partition.
Yes.
Another suit was filed in the year 2011. That is for suit for partition. There they showed that already in favor, in respect of that property, expiry decree was there, so that suit was, my lord, on the ground of residuator was rejected, was dismissed. That order was challenged before this Honorable High Court by first appeal. That is another.
Against which, my lord?
On the preliminary form.
How preliminary degree can be passed?
Without deciding the issue of each and every case.
This is a partition suit.
Yes, after this partition goes, again the same ploy has been taken.
That is one of the co-share by Sujata.
One co-sharer, I think one co-sharer, 44 and 40 is undivided property. So suit for partition. The Honorable London Trial Court came to the finding that you have no right title. There is a direction for handing over possession. In view of this same, suit was dismissed. Against that, they came before this honorable court. Initially, it was allowed to be dismissed for default. After that, this order was passed. Probably my learned friend also quite aware of the same. So today, what there after that?
No. This is a suit for declaration and eviction.
Yeah, declaration and eviction. Their lordship find there is an eviction, and this is the suit
For partition.
for partition which was held. My lord
No, this order which you have handed over, this
It
is
is for eviction degree. There is a Judge Sahib, क्या होता है? Page 4, your lordship will find.
yes.
And this is the satisfaction recorded for the execution case. Now, my lord, I am only on the basic things, my lord. If any illegal construction, they have already demolished my wall. It is already demolished from the report on the earlier occasion. Now, they said that temple was there. There is no worship, so it is a vacant temple. According to them, it should also be demolished. I put this question to myself: the club is taking, be as it may, adjacent owner is also entitled to raise if any illegal construction is made. So it is not in the month of November 2023. From their report, it will be a pretty long time that Mandir was there. Even if Manar Kali consider, according to us, it is long back. Even if taking into account that it is illegal, then also Manar, the power is vested with the commissioner to say whether it is, because it is not the subject matter of dispute, the commissioner did not take into account of this only, but only the boundary wall, what was the subject matter of dispute, that was already demolished. If it is their opinion that it is illegal, then Manar necessary steps be taken. Otherwise, how the petitioner is, it is nothing but a ploy to create some litigation just to avoid us from entering.
So the temple is in some other plot.
Yes, that is what Manar I am submitting. In which plot the temple is there? Let the commissioner should come forward and say. Because initially, Manar, that's why Manar draw your attention. Only a Bata plot, it is the construction was there.
But to the
In the Bata plot, the construction was there. It was mentioned, which is amalgamated or impartable from the plot number 448. It was a basic case whether the temple is in Bata plot or parent plot.
to the Bata plot is portrait dekhan. My lord, kindly come to page number 46. My lord, I am humbly praying you, Lord, kindly come to page number 46. Lord, kindly come to page number 46 of my reply. Of my reply. Of my reply, my lord. Page number 46 of my reply.
Huh.
So, Lord, kindly come to page number 46. That is RS plot, so RS portion. মানে there your lordship will kindly see ভুবন চন্দ্র দত্ত, পিতা
আসো,
নবীন
আসো,
চন্দ্র
কালকে
দত্ত,
রাখো।
অমূল্য চন্দ্র দত্ত, জ্ঞানেন্দ্রনাথ দত্ত, মহাদেব চন্দ্র দত্ত, ননী গোপাল দত্ত,
কালকে দেখো।
মানে from all the three sharers I my lord got the property.
কালকে কি আছে? No, there was a submissions from the side. Mr. Banerjee appeared. Yes. Huh? That there was a talk of settlement going on between the parties.
What they're trying, my lord, no. Practically, they have been beaten and thrown out from the
No,
this club.
that is not.
What is, my lord, I have a person,
They have-
my lord, Kali considers for 1997 we are fighting this litigation, my lord, knows what is the effect. Now, my lord, the position somehow they are unable to protect. Now, somehow, this is going on.
My lord,
Even if
they are-
my
they
lord,
are-
if it is
my lord, your lordship kindly hear me. They are fighting, but they should fight. They should take their own share. There are five co-sharers in the said property. Five co-sharers on the from other three co-sharers we have purchased the land.
the
From
limited
Nobin
knowledge
Chandra,
we have,
from
my
Nobin
lord,
Gopal Dotto,
the
Nobin
civil
Chandra
court's
Dotto, we
degree is
purchased the
binding
land.
upon
কালকে কত?
until and until
Five co-sharers in the said
Yes.
property.
কালকে কতগুলো
They
আছে?
can take their own share. We have no objection, my lord. He grabbing, trying to grab the entire property.
the imposter is directing the owner to take property.
So how can it be ascertained that whether the temple lies on the plot in question or not?
Their
Undivided.
case, it is their case, my lord. Even if my lord, the temple is there in either of the two plots, my lord, the temple must be there. If that be so, my lord, it is a 20 square feet subject to correction. My lord, it is 20 square feet temple. If under
Square
the
meter, I suppose. It is not square feet, it is square meter.
square meter, 20 square meter, this is the temple. If it allows by now the under the temple the provision under the act, the commission has the power. If it is an old temple, the commission has the power under the Temples Act to consider the same, and it should be immune from demolition. And if it is a commission who's found after inspection, no, it is a new temple has been constructed after promulgation of the act, then my lord, he has the demolish the same. There is no dispute about the same. I also cannot stand if someone will come and say, I have constructed a temple, it can be demolished. On the temple act, a particular date has been cut off, date has been fixed. Prior to that, those temple has been directed should be kept. Now, it is a commission who has the every authority. My learned friend is there. He can prove that yes, it was there after that act. If we can satisfy the commission that it will be done prior to that act, then I take the benefit of the same.
Yes.
So this keeping
When can this law be placed before this court? Because they have said that there is an existing temple
yes, yes.
and they have placed certain photographs which shows that it is a new construction of the temple. I don't know what is it.
That is why, my lord, I am on that. If the commission is found that it is illegal direction for demolition, the commission has the power on the earlier occasion also. So there is, according to my submission, my lord, it can be done in that way also, subject to my lord's.
What is the express provision? Can you just
177 subsection 1.
177.
okay?
I'll may read out the
Municipal Corporation Act.
How Municipal Corporation Act.
Thank you.
Which is it? Those?
No, wait a minute.
No,
কেটে কেটে রেখে দাও তো কালকে রেখে দাও
17.
Who is for the corporation? Heard, Mr. What is your name? Okay.
And this amendment was brought by a notification dated 15/9/2017. That the power to division and
Heard, Mr. Partho Pratim Roy, learned advocate for private response numbers 5 to 7. Mr. Shantanu Chatterjee, learned advocate, indicates that his name has not been recorded in order dated 3rd December 2024. Let the name of Mr. Shantanu Chatterjee, learned advocate, be also read in order dated 3rd December 2024 for appearing for Howrah Municipal Corporation. কালকে বা মানডেতে যে কোনো একটা দিন কালকে
I'll keep it on Monday.
tomorrow
Tomorrow.
My lord, if I am not there, my lord, I'll be out of station. I'm also canteen. My junior will be here, my lord. This is my submission, my lord. If your lordship wants, I can assist your lordship to provide any act and statute which is followed from your lordship. I'll provide.
you just if you are not there then you ask Mr. Dutiman Banerjee
Yes, certainly.
to produce that particular
Yes.
since you have no objection if there is a act prevalent and they say that it is illegal, let it be.
Also, these two provisions.
This can be removed.
If it is removed or it can be retained. This is the only two things. But kindly consider how the club is doing all these things, my lord. Kindly consider this plight of the litigants who is litigating since 19 plus 34 years. They enjoy the fruit of the degree.
Yes.
Grateful, dear lordship.
Monday.
Alright.
Monday.
Just keeping my lords waiting after the recess.
It's all right.
Yes.
Monday. Monday, sir.
Any mentioning?
Lord, yesterday, Lord, I had mentioned a matter, Lord, for leave, Lord. to
Yes,
drop
yes.
it.
কি হয়েছে অঞ্জন?
Records are there, Lord. Just need a formal leave of your Lordship. Lordship grants leave, Lord. I don't think there's any difficulty.
Leave granted.
I'm grateful. Very good.
Regular bench for judgment.
I'm appearing is my application which your lordship has decided.
GA1 of 2023 is allowed. The execution case 180 of 2023 is dismissed. Let there be order in terms of prayer A of the Master Summons. In the chamber.
Daily list commercial bench item number 1.
How many exhibits were done yesterday? 2. Taken a check করে নিন তো 2, 1 and 2. Yes.
আপনার নাম স্যার? দেবাশিস সাহা। দেবাশিস সাহা স্পেলিং EBA। আচ্ছা ঠিক আছে। Yes sir.
Mr. Shaha, can you apprise the honorable court with regard to?
স্যার শুনতে পাওয়া যাচ্ছে না।
Can you apprise the honorable court?
Page number.
Whether. Can you apprise the honorable court? What are these 3 letters about? And who has signed those letters?
Page 19. আচ্ছা পেজ নাম্বার 19, 22 এবং 25-এ যে 3টে চিঠি দেখা যাচ্ছে, একটু মাই লর্ডকে বলুন যে চিঠিগুলো কি ব্যাপারে?
এটা হচ্ছে আমরা যে বিল্ডিং এ এতদিন ছিলাম সেই বিল্ডিংটা হচ্ছে খুব খারাপ কন্ডিশন ছিল, ঠিক আছে?
The building in which we was residing till now was in a very bad condition or dilapidated condition.
Not residing, this is an office.
ছিলাম my lord, he said.
No, this is an office, no? Office being carried on. Residing হবে না।
On the building that was the office was going on. Our office was there. The building in which our office was there was in a very bad condition or dilapidated condition. Yes.
এটা আমার প্রাক্তন বসের এগুলো সাইন করার চিঠি।
This is a letter sent by my ex-boss, who has also signed this letter.
The boss record করবেন না। What is the rank of that officer who issued that letter?
Senior divisional manager.
Okay, senior divisional manager.
Senior divisional manager.
What is his name?
SM Chura.
SM Chura. SMCHURA.
Yes.
Are you aware of the signature which is appearing in those letters?
এই চিঠিগুলোতে যে
আমি টোটালি সবে এগ্রি করছি, এটা ওনারই সই করা।
I am totally aware of those signatures. This is the signature of him. The letter sent by him.
Letter will be accepted.
The contents of the 3 letters are same.
Different, but this all relates to the repair. So I
Okay.
split it.
Page 19, 22 আর 25 তিনটে আছে। এটা 3।
25 সেপ্টেম্বর আর 4 অক্টোবর।
Page initial letter, the letter appearing at page number 19 is marked as Exhibit 3/1. The letter appearing at page number 22 is marked as Exhibit 3/2. And the letter appearing at page number 25 is marked as Exhibit 3/3. Yes, sir.
Mr. Shah, kindly come to two letters dated 25th September 2002 and 4th October 2002.
Appearing at page 20. এই চিঠিগুলো কি ব্যাপারে মাই লর্ডকে বলুন।
Mr. Shah, kindly apprise my lord, what are these document about?
কি ব্যাপারে চিঠিগুলো?
ওনারা যে রিপেয়ার করবেন সেই সংক্রান্ত ব্যাপারে চিঠি দিয়েছে।
This was a letter regarding the repair they have to carry out or done. They had to done.
Did you receive this letter in course of your regular business?
আপনি কি রেগুলার কোর্স অফ বিজনেস এই চিঠিটা পেয়েছিলেন?
হ্যাঁ, রেগুলার কোর্স অফ বিজনেসেই এই চিঠিগুলো।
Yes, I received this letter, the regular course of business.
This two letter will be marked as exhibit. Will be exhibit.
Exhibit? দুটো।
4/1 আর 4/2 করবে না? 4/4 না 3 সিরিজটা হয়ে গেছে। 3 সিরিজ এক্সিবিট হয়ে গেছে।
জাজেস ব্রিফ অফ
তিনটে ডকুমেন্ট করতে তার মধ্যে যা আসবে
তাহলে the letter appearing at page number 20 is marked as Exhibit 3/4 and the letter appearing at page number 23 is marked as Exhibit 3/5. 20টা 3/4 আর 23টা 3/5.
হচ্ছে 21শে জুলাই 27
The 29 and 33 এই দুটো চিঠি দাঁড়ান এখন কোশ্চেনটা করেননি আমি
Mr. Shah, kindly apprise what these two document about and whether you are aware of the signature who has made at the bottom of that.
এই দুটো ডকুমেন্ট কি ব্যাপারে মাই লর্ডকে বলুন এবং এই দুটো ডকুমেন্টের শেষে যে সইটা আছে আপনি কি সইটাকে চেনেন বা জানেন সেটা বলুন।
এটা সেই সময় ইলেকট্রিকের সাপ্লাই একটা গন্ডগোল ছিল, সেই সংক্রান্ত ব্যাপারে সিএস দাস স্যার এটাকে সই করেছিলেন।
At that point of time there was an electrical problem. This document was issued or this document was signed by Mr. C.S. Das.
Senior Divisional Manager.
C.S. Das, Senior Divisional Manager.
Are you acquainted with the signature of your senior divisional manager Diden?
আপনি কি তৎকালীন সিনিয়র ডিভিশনাল ম্যানেজারের সইয়ের সঙ্গে পরিচিত?
হ্যাঁ, আমি ওনার সিগনেচার সম্পর্কে অবগত আছি।
Yes, I am acquainted with his signature.
These two letter will be exhibited. 3/6 and 3/6.
The document appearing at page number 29 is marked as Exhibit 3/6 and the document appearing at page number 33 is marked as Exhibit 3/7. Yes, sir.
That's all.
My lord, I'm being led by Mr. Bose, my lord. My lord will kindly keep the cross-examination on the next page.
It's not this.
Not right now. My lord, he's in court, but I believe he's engaged somewhere else.
Start cross-examination.
Has this affidavit been prepared at your instance?
এই এফিডেভিটটা কি আপনার নির্দেশে প্রস্তুত করা হয়েছে?
হ্যাঁ, এটা আমার এতেই এটা
Yes,
তৈরি করা হয়েছে।
the affidavit was prepared at the instance of mine, at the instruction of mine, at my instruction.
Under my instruction. So Shaha, in paragraph, kindly look at paragraph 7 of your affidavit.
এটাই কি? এটাই
Affidavit.
Affidavit is
paragraph
7.
7.
Yes.
Yes, madam. Stone affidavit of evidence.
Shaha, you have stated in this paragraph that the building which you were occupying was in a dilapidated condition. Am I correct?
Yes.
You have also stated, not in this paragraph, but in your affidavit, that there have been massive disruptions of power supply while you were occupying the premises. Is it correct?
আপনি যখন Yes.
In which of the paragraphs you indicate that will be convenient?
Very well. I will. My lord will kindly give me one more. Dilapidated. My lord, may I come back to that paragraph number? My lord, I shall.
Okay.
Mr. Taha, for how long are you employed? Since when are you employed with the defendant company?
ডিপেন্ডেন্ট কোম্পানিতে আপনি কবে থেকে কাজ করছেন?
আমি 1992 সাল থেকে আমি এখানে কাজ করছি।
Since the year 1982, I am working.
92
Oh, sorry, 1992, I am working with the defendant company.
My lord, in the previous question, my lord, I was referring to paragraph number 9 of this affidavit. So you have stated your affidavit in paragraph number 9.
আগের কোশ্চেনটাতে আগের কোশ্চেন এই যে ম্যাসিভ পাওয়ারে যেটা বলছিলেন প্যারাগ্রাফ নাম্বার 9 এর
Now, till when did the defendant continue to occupy the premises?
ডিফেন্ডেন্ট কবে থেকে এই যে জায়গাটার বিবাদের জায়গা সেটা কবে থেকে অকুপাই করে আছেন বা নিজের দখলে রেখেছেন?
এটা assurance. Royal Exchange Assurance 1963 থেকে এই অফিসে আছে। এরপরে 72 তে
From the year 1963, Royal Exchange
Assurance
Company is there in the premises.
সেই সময়
আর কিছু বলবেন?
তারপরে 1972 সালে 1972 তে ন্যাশনালাইজেশন অ্যাক্ট হওয়ার পর ন্যাশনাল ইন্স্যুরেন্স কোম্পানি হিসেবে এই অফিসে
After that, in the year 1972, after the Nationalization Act,
1972
the company was there. The company remained there. Koro.
So Shah, my question was, till when did the defendant occupy the premises?
Defendant কবে থেকে এই
কবে
premise-
অবধি এই
ও
property?
এটাই
Till when?
গত বছরে হচ্ছে 29 সেপ্টেম্বর 2023 এই দিনকে আমরা চাবি হ্যান্ড ওভার করে দিই।
we handed over the keys on 29 September 2023.
Now please come back to paragraph 7 of your affidavit.
Yes.
In paragraph 7, you have relied upon documents pertaining to the year 2002-2003 to state that the suit property was in a dilapidated condition. Am I right?
Huh.
And in kindly come to paragraph 9, you have stated that massive power disruptions were faced by you in the year 2005.
Huh.
Am I correct? So therefore, the disruption in power supply as well as the dilapidated condition of the building did not prevent you from occupying the premises till September 2023. Am I correct?
Yes.
Kindly come to paragraph 12 of your affidavit. You have referred to suit number 661 of 1983 in this paragraph.
Huh.
Do you know why this suit was filed?
আপনি কি জানেন এই স্যুটটা কেন ফাইল করা হয়েছিল?
মানে ভেকেট করে দেওয়ার জন্য
কাদেরকে বলুন? কোথা থেকে? To vacate the tenants. This suit was filed to vacate the tenants.
Who were the tenants at that point of time?
কারা টেন্যান্ট ছিলেন সেই নির্দিষ্ট সময়ে?
রয়্যাল অ্যাসিওরেন্স কোম্পানি ছিল।
Royal Assurance Company was the tenant at that point of time.
Was the tenancy given under? Was there any educated? Was there any agreement by which the tenants were inducted in the property?
কোনো কি চুক্তির ভিত্তিতে ভাড়াটিয়াদের টেন্যান্টদের কি বসানো হয়েছিল?
এটা একটা এগ্রিমেন্ট ছিল, সেই অনুযায়ী এটা হয়েছিল, কিন্তু এটাতে কোনো টার্মিনেশন ক্লজ কিন্তু
Yes,
ছিল না।
the tenants were inducted on the basis of an agreement, but there was not any termination clause included in that agreement.
Do you remember the date of the agreement of which you made a reference right now?
আপনি এক্ষুনি যে এগ্রিমেন্ট বা চুক্তির কথা বললেন তার তারিখটা কত বলতে পারবেন?
1983 এই ইয়ারটা বলতে পারবো।
The agreement was made in the year 1983.
বলুন।
ধরে যাবেন, খোলা আছে, একটু আলগা আছে।
Mr. Shah, kindly look into Exhibit A. Exhibit A, agreement. A mone hoy, A no?
Yes. The agreement was made with 1983. One exhibit A.
Mr. Shah, kindly look into this agreement. What is the date of this agreement?
এই এগ্রিমেন্টটা দেখুন তারিখ বলুন।
7th day of May 9,000
1000 sir
1984.
7th May 1984.
Kindly look into page 2 of the agreement of Exhibit A.
Second page also. Yes.
To find that the expiry of the lease executed in the year 1963 was the basis of the suit, being suit number 661 of 1983.
Yes. Yes.
So I suggest to you that the deposition that you are, that the evidence that you are tendering now is false and correct. So whatever you have, sorry, I suggest to you, whatever you have deposed till now is false and incorrect.
উনি আপনাকে সাজেশন দিচ্ছেন, আপনি মানতেও পারেন নাও মানতে পারেন। উনি বলছেন আপনি যা কিছু সাক্ষ্য দিচ্ছেন
না,
সেটা
আমি just একটু rephrase করি, whatever you have stated in your affidavit in evidence is false and incorrect.
আপনি আপনার এফিডেভিটে যা কিছু বলেছেন তা মিথ্যা এবং সঠিক নয়। আপনি মানতেও পারেন নাও মানতে পারেন। আগে মানছি বা মানছি না বলুন, তারপর উত্তর দিন।
না, এটা যেটা দেওয়া আছে এটা কিন্তু ঠিকই দেওয়া।
আপনি মানছেন না, তাই তো? I disagree. The witness volunteers the statements made in the affidavit of evidence. I disagree. The witness volunteers the statements made in the affidavit is true and correct. Are you okay, sir?
What is the difficulty? বসবেন উনি?
না, একটু জল খাও।
আপনি বসুন।
Your Lordship, please stop.
আচ্ছা এই করে দাও। দেখুন অঞ্জনবাবু,
My lord, means
ডাক্তার ডাক্তারি করো, ডাক্তার করো।
ডাক্তারকে খবর দিই, ডাক্তারকে।
বডি খারাপ হয়ে আছে, বডি ঠিক হয়ে আছে,
একটু জল দিই, জল।
ঠিক আছে, ঠিক আছে, ওকে ওকে ওকে, টাকা 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 ওকে 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 টাকা টাকা টাকা
দরজা খুলে দাও।
কিছু দিয়ে হাওয়াটা মাথাটা দেবো। ঠিক আছে,
এই কে আছো এখানে? এই পাখাটা চালাও না, এই দিকের পাখাটা, এটা চলো।
একটু
না না নার্ভাস হয়ে পড়েছিলাম তো আমি কোনো অসুবিধা নেই, কিছু হয় না, কিছু ঠিক আছে। হ্যাঁ ঠিক আছে ঠিক আছে আপনি চাপ নিয়ে ফেলছেন। ঠিক আছে অল্প গ্লুকোজ দেয় ঠিক আছে ঠিক আছে ঠিক আছে আজকে আপনি রেস্ট নিন, আজকের মতো কমপ্লিট হয়েছে, আবার পরে দিন।
ওনাকে শিফট করবেন না ওখানে বসে থাকুন।
হ্যাঁ কথা বলছি না কথা
ওখানে of National Insurance Company Private Limited is examined in chief in full and cross-examined in part. List this matter for further cross-examination on. এটা দেখুন টেবিলটা দেখুন কবে দেব কবে ফেব্রুয়ারি আচ্ছা ফেব্রুয়ারি কবে আসবে তাহলে একটা পিছিয়ে যাবে মাঝখানে কি অনেক আছে নাকি 13 তো থার্সডে 12 February 12 February এই নিন অঞ্জল বাবু ওর খবর দিয়েছে সে ডাক্তার দেখে তারপরে যাবে
দেখে নেবে আমাকে হ্যাঁ হ্যাঁ ঠিক আছে আপনার পাচ্ছি কি রয়েছে কি তাহলে কি বাইরে যাবেন অসুবিধা হলে বমি পাচ্ছে
Ajul Babu, please don't shift him right now. Let the doctor come. এখানে বেশি না
Item number 2.
Not today. Next.
Item number 3.
By the outcome of instance of the receiver.
Plaintiff. Receiver.
Since the bids have been received, my lord, I would be beseeching your lordship, my lord, to place the matter on the 23rd of December, when we can come back regards the confirmation of the same.
So, what is the purpose of filing the bids in this court? The receiver can very well take decision of the highest price which has been bidded.
My lord, that price needs to be disclosed, my lord, whatever the highest bid
Yes,
which
ma'am,
has
the
been
highest-
received with regard to the sale of the property.
So, by way of a report, that should be placed before this court.
My lord, that has been circulated before the court, I believe, my lord, today.
So, that is not there. It is a sealed envelope. The receiver has to open that and then find out and file a report that this is the highest bid. Following has given, these are the bids, this is the highest.
Lordship to kindly, my lord, let
Yes?
Sorry, but I'm appearing on behalf of the receivers. Pursuant to orders passed by a lot, that we have the receivers with us. They went to Rajasthan and they have pursuant to a publication received bids in sealed covers. Today, Millard, we are going to hand up to your lordship a compliance report regarding the receipt of our bids, and your lordship, Millard, can open those bids.
No. Then open in court and then find out who is the highest. This exercise, then what is the purpose of appointing a receiver?
We'll do that, Millard. We didn't have your lordship's expressed permission in the order.
So that is what is explicit in the order, that the receiver has to call for the bids and then decide which is the highest bidder.
The envelopes also have the demand drafts, earnest money deposits.
Ah.
So now that your lordship is expressing the permission to us, we
Yes.
will do that and file the report. Millard, your lordship can fix any day.
This matter is appearing under the heading to be mentioned. Mr. Rohit Banerjee, learned advocate, appearing for joint receiver, submits that pursuant to order of this court, publication for sale has been made and bids have
11 bids.
11 bids have been received. Joint receivers are directed to consider the bids and place a report on the returnable date. You mentioned all the 11 bids and why consider highest, huh? What are the heading?
My lord, the date fixed for confirmation of sale is 23rd of December in the notice. In the notice inviting offers, it is fixed for the 23rd of.
You can stand over the vacation because this is going to take some time.
Okay. How long?
The lordship can keep it on 3rd because this
Third.
has to be done below the
Okay. 6th January.
Millard, will make one submission pursuant to your lordship's order. Your lordship has directed the party to pay rupees 4 lakh to be divided among the receivers. Millard, they have only paid 50% of the difference. Several orders passed by your lordship, Millard. I'm being handed up. This is very embarrassing for us.
Direction, what I have been instructed is that the initial direction was for payment of 2 lakhs. Since the earlier 2 lakhs was not cleared, so therefore the 2 lakhs by subsequent order was directed to be cleared. It was not 2 plus 2, 4 lakhs.
Mr. So learned advocate for the plaintiff as well as defendant numbers.
For the defendants, there are many defendants.
Defendant.
That remuneration will be.
This cannot be a contingency, sir. They are in fact staking their lives going over there where they are facing lot of hostility. They are taking lot of responsibility. The lordship is.
Where is Mr. Gupta?
Yes, my lord.
Why the remunerations are
My
not
lord,
being?
the remuneration has been paid by the plaintiff, nobody else, out of 80 parties in the suit is coming up and paying the receiver's remuneration. But what I would humbly
Say that
beseech,
they have not received.
well, 2 lakhs they have received.
50% has been received.
No,
List,
they have
list.
received 2 lakhs. Well, only one thing, if your lordship kindly permits. But if out of the sale proceeds, because the plaintiff has also borne the cost for travel, accommodation, and the like for the receiver.
No, no,
apart
you
from
pay
the
the remuneration.
But if
List 50%, you pay that.
then we shall pay. But only one thing, if your lordship kindly
Joint
provides that
Gupta,
from the
Aditi
sale
Bolam,
proceeds
Mr.
initially,
Banerjee, learned advocate for the joint receiver, submits that the 50% remuneration is yet to be received by the joint receivers. Mr. Choyan Gupta, learned advocate for the plaintiff, and Ms. So and so, learned advocate appearing for the defendant, undertakes that the remuneration shall be paid within
The returnable date.
within the returnable date. Yes. Please, this was sixth bullet.
Instruction with regard to the fees of the receiver, my lord. There are 40 defendants. We need a little instructions with it.
What instruction?
My only humble submission
There
is
is a-
order of court.
Since there is a little dispute concerning the fee, whether it's 4 lakhs or it's just 2 lakhs, my lord, that needs to be clarified.
Only one thing. Whatever it is there, we'll sort it between ourselves, and your lordship need not be troubled. And we shall sort it between us.
I'm keeping up.
Item number 4, regular bench.
My lord, I'm appearing for the applicant in this matter. What is to that Everest House building, my lord. My lord, on last occasion, my lord was pleased to pass an order directing paper publication. We have carried out the paper publication, my lord. My affidavit of compliance.
No.
I'm for the defendant number 10, Owners Association.
Yes. What do you want now?
My lord, pressing for prayer B and C, B and D, my lord. For appointment of a special officer or receiver for carrying out the execution. My lord, similar kind of matter, my lord was pleased to pass an order which appears in page number 104.
Okay. Any dues to the association? Any dues are there? Any dues are there in the? This is an application for execution of deed of conveyance in respect of office / flat number 15 capital A/1 along with a pantry and toilet situated on the 15th floor of Everest building at 46 C, capital C, Jawaharlal Nehru Road, Kolkata 700071. Mr. Ritik Chaudhary, learned counsel appearing for the petitioner, submits that pursuant to order of this court, paper publication has already been made. He seeks for appointment of a special officer to execute and register the necessary deed of conveyance. He files affidavit of compliance, which is taken on record. Considering the averments made in the application and the submissions advanced on behalf of the petitioner, let there be order in terms of prayer. B. And the notice of motion to the
B and D.
B and D of the notice of motion. Mr. আর নাম দেবো হাতে দেখে দিন বা কেউ প্রেজেন্ট আছে তাকে দিয়ে দাও কে কে আছে আচ্ছা মিস্টার সুমিতাভ চক্রবর্তী learned advocate within bracket bar association room number 5 enrollment numberটা আছে 5 is appointed as special officer to execute and register the deed of conveyance on behalf of Western Building Corporation. Next, the remuneration of learned special officer be fixed at rupees 2000 James. The learned officer, special officer, next line of comment, shall submit a report after completion of registration of deed of conveyance on the returnable date. When can this be completed? Of reopening?
My lord, from today.
From Still, okay. Is this matter on? Three weeks after vacation.
There is some urgency because the applicant is leaving for his son resides in USA. He is leaving for USA. That event, if it is done within 2 weeks from the date of reopening, ma'am.
Date the 17th January.
Item number 5.
Item number 5, Your Lordship, I am appearing on behalf of the plaintiff. My Lord, in this matter, I'll bow down and, my Lord, apologize because there has been a change in the advocates for both the parties for a long time. As per the records, my Lord, I have a ready affidavit, a formed affidavit of documents with me. There are letters which shows, my Lord, we have asked the advocates to come for the discovery and inspection of the documents, but, my Lord, they have not done it. So, Lordship kindly passes in order to that effect, the suit may be proceeded with, and the discovery and inspection may be done, and the affidavit may be
last
signed.
order.
I may just indicate, my Lord. There's one difficulty, Your Lordship. The server copy orders are not available in the CIS.
Is suit for eviction?
Yes, my Lord. This is a suit for eviction.
Who is for the defendant?
Lordship.
Given a notice to the defendant
Yes,
to
yes.
cause inspection
There have been several notices, Your Lordship.
for causing inspection?
Yes, my Lord. Back in 2019 and 20 from the brief that I have gotten. Hence, my Lord, there are no orders that are available presently on the server. I would humbly submit that Your Lordship passes an order to that effect so that we can attach that order and give a further notice.
Which are the orders which are not available? Indicate that. Orders will check on
Lordship, in this suit, initially it was filed by, my Lord, 5 plaintiffs.
After vacation, in the meantime, dependent advocate on record notice দিয়েনি ওদিকে তাহলে দেখে নিয়ে করে দেবো। This matter is appearing under the heading to be mentioned. Para. Mr. So-and-so learned advocate for the plaintiff submits that the you have filed your documents.
Lordship, I have the original affirmed copy with me. I'm seeking leave, my Lord. I have to affirm it afresh because it is as per the old rules of filing.
Seeks leave to file. This is affidavits of documents.
Documents, Your Lordship.
Affidavit of documents. He also informs the court that several notices has been issued to the advocate on record for the defendant for causing inspection of the documents of the plaintiff. But till date, such inspection has not been made by the advocate on record for the defendant. In view of the above, learned advocate on record for the plaintiff is directed to serve a notice upon the advocate on record for the defendant, intimating the next date. Release this matter on 20th January under the same heading.
Grateful, Your Lordship.
Give a notice to the advocate at the end.
Obliged, Your Lordship. Certainly. Grateful.
Item number 6.
I appear for the plaintiff.
My lord's last order of 3rd of October records that a commissioner was appointed for recording the evidence of my witness. The work was going on. 5 sittings has been held. Documents are being exhibited. Up to the 5th sitting, the defendant appeared. Now the 6th sitting, which was held on last 12th of December, the defendant suddenly disappeared. They are no more appearing, the defendant lawyers. Now, we have been informed verbally that they have no instruction.
Who appeared? This is that matter in which the judge's brief of documents are not.
Yes. Till date, we have done inspection, everything. They have not yet given the judge's brief. They have neither provided us with any documents also.
Who was for the defendant?
Now, last order down I was. The Imon Bhattacharya. Mr. Shamol Chakraborty and Imon. I think Imon is the advocate on record or whatever. This is a copy. My lord had given them a liberty to for this judge's brief and all. These are
Find judges defended.
The defendant was at liberty to file their documents. They haven't not yet. The commission's next date is fixed on 23rd of this month.
So what do you want? If they are not appearing, then it has to be closed. The decision is with the commissioner to take.
Yes, that's the reason. That is the last. This is the order of the commissioner. The last order. No, sorry. This is the last minutes of the commissioner. Now, we can proceed. The matter was returnable on 15, so it is now before the court.
Your chief is complete?
No, it's not yet complete. I'll require 1 day for some documents for to be exhibited.
When it is coming up on 23rd?
23rd is the next date fixed by the commissioner. Those 2 days were already fixed on 17th and 23rd. 17th, nothing happened yesterday because there was no court yesterday. Now is on the Monday is 23rd. But we may proceed with the commission work.
This matter is appearing under the heading to be mentioned. Mr. Aniruddha Mitra, learned senior advocate, appearing on behalf of the plaintiff, submits that the examination of witness before the advocate commissioner is yet to be completed. List this matter under the same heading. On 23rd it will be completed.
May not be. Maybe come back on 15th of January or thereafter, the 3rd week of January.
List this matter.
In the meantime,
on 15th January, देखिए 15th देखो.
Any day. 16th.
16th January under the same heading.
Well, the only one observer's commissioner was with the view that whether he will continue that the commissioner may proceed with the work because that's the observation.
What was the last date for concluding the commission work?
15th was the order. Miller's order record, the commissioner filed a report by 15th December. The order which I handed over to us. So the time is extended. 3rd October.
15th December. The time to file report by the learned advocate commissioner is extended till the returnable date.
Another thing, the commissioner's fees, which was initially ordered by the court, was 40,000. We have paid that. But a similar, make a order, a similar remuneration, we'll pay him once again.
Let him complete that, come up with a report, and thereafter.
My duty to inform.
Who is the commissioner? Who is the commissioner? Who is the commissioner?
Mr. Swarnendu Ghosh.
Okay.
Will come.
I don't know, 7.
appear for the plaintiff, my lord. But on the last occasion, my lord, since none appeared for the caveator, my lord, lordship had directed us, my lord, to serve a notice upon the caveator as well as, my lord, the advocate report. My lord, we did that on the very next day, my lord, but my lord, the service is still, my lord, incomplete because it's still out for delivery, my lord. The lordship keeps it on 24th, my lord. In the meantime, we'll see if the delivery has been effected or not.
Matter is appearing under the heading to be mentioned, Mr. Sayyid E. Huda, learned advocate appearing for the plaintiff. Petitioner, no?
Now plaintiff, my lord. Now
Plaintiff.
it's become a testamentary.
Plaintiff submits that pursuant to order of this court, notice has been issued to the caveator. Advocate on record also. Advocate on record for the caveator as well as the caveator. However, the report of service has not yet been received. In view of the above, place this matter on January 6th. Same ऐसे करो दें under the same heading.
Obliged.
For witness action, item number 8.
What's the box? Continue. Please, my lord, we change the position. Petitions can be.
My learned friend is examining, so naturally.
Where is your witness? Oh.
বেশ খারাপ হয়ে যাবে কিন্তু
Initiation.
স্যার আপনার নাম
গৌতম রায়
গৌতম রায় একটু ছোট ছোট করে আস্তে করে বলবেন
বুঝতে আছে অনেকগুলোতে
May I hand over a copy of the last day's deposition, mother? Question one. I'm told, mother, the deposition has been handed over to your lordship. Maybe provided supply a copy of it to the witness.
Okay.
The vote and Mr. Raj, sorry. Kindly answer to question 65 of your deposition dated 22nd November 2024. And in my lord, steps and tell my lord whether you got in touch with your chartered accountant.
কোন কোয়েশ্চেন নাম্বার 65 স্যার এটা দেখুন এবং মাই লর্ডকে বলুন যে আপনি আপনার চার্টার্ড অ্যাকাউন্টের সঙ্গে যোগাযোগ করেন
আমি দ্বারিকনাথ ভট্টাচার্য আমার অ্যাটর্নির পরামর্শ মতো আমি চার্টার্ড অ্যাকাউন্টেন্ট রবীন ব্যানার্জির সঙ্গে যোগাযোগ করি উনি আমার কাজ করতেন।
As per the guidance of my lawyer Dariknath Bhattacharya, I contacted with
রবিন ব্যানার্জি,
Robin Banerjee,
চার্টার্ড অ্যাকাউন্টেন্ট।
my chartered accountant.
আমি ওনাকে এন্ট্রাস্ট করি বিনাগুড়ি ইনভেস্টমেন্ট কোম্পানি ডিফেন্ডেন্ট নাম্বার 3 এই কোম্পানির
ছোট ছোট করে একটা একটা করে বলুন।
বিনাগুড়ি ইনভেস্টমেন্ট
আমি ওনাকে
ইন্টারেস্ট করি।
I made him the interest ভুল যাচ্ছে না দেখুন
ইন্টারেস্ট করি বিনাগুড়ি ইনভেস্টমেন্ট কোম্পানি ডিফেন্ডেন্ট নাম্বার 3 এখানে
Binaguri Investment Company, which is defendant number 3 in the current proceeding, the current suit.
এই কোম্পানির শেয়ার হোল্ডিং, ব্যালেন্স শিট, আপ টু ডেট স্ট্যাটাস ওই তারিখে কি ছিল সেটা সম্পর্কে কি কাগজ পাওয়া যায় সে সম্পর্কে ডিটেলস এনকোয়ারি করতে বলি।
I entrusted him with the ওই বিনাগুড়ি এটা হলো কি কি জিনিস দিয়েছিলেন একবার বলবেন?
আমি ওনাকে বলি যে শেয়ার হোল্ডিং অফ দ্য কোম্পানি, শেয়ার হোল্ডিং অফ দ্য কোম্পানি, কোম্পানির ফান্ড পজিশন,
the fund position of the company,
ব্যালেন্স শিট যেগুলো সব মানে পুরনো ব্যালেন্স শিট 80-81 থেকে,
all the older balance sheets since the year
80-81 থেকে আর ওই 92 পর্যন্ত একটা ইন্সপেকশন নেওয়ার জন্য বলি।
and requested him to make an
have an inspection
till the year
up to 1992
up to the year 1992. আর কিছু বলবেন?
হ্যাঁ,
হয়নি।
উনি দুদিনের ভেতরে আমাকে সমস্ত স্ট্যাটাসটা মানে ওখান থেকে সার্টিফাইড কপি পাওয়া যেত না, উনি যেটা পেলেন সেটা হচ্ছে হাতে লিখে নিয়ে একটা রিকুইজিট ফিস দিয়ে উনি হাতে লিখে পুরো স্ট্যাটাসটা আমাকে এনে দিলেন এবং বললেন
সিম্পল সেন্টেন্সে বলুন, he give me the status report within 2 days. At that time certified copy
এইভাবে পাওয়া যেত না।
at that time certificate copy was not available. উনি কিভাবে দিয়েছেন?
উনি আমাকে ইন রাইটিং ওর কপি নিজে হাতে লিখে এনে দিলেন।
he gave me it in writing
with ওই রিকুইজিট ফিজের কাগজটা সমেত,
with the document of the requisite fee, with the paper of the requisite fees.
বলি
হ্যাঁ স্যার বলুন।
উনি আমাকে বললেন
he told me that
যে আমার অনেক কিছু বলার আছে,
I have to say a lot of things.
আপনি আমাকে আপনার সলিসিটর দারিক বাবুর অফিসে নিয়ে চলুন।
I have to say a lot of things. Please take me to the office of your advocate, Mr.
নাথ ভট্টাচার্য। আমি যা বলবো আপনিও শুনবেন, উনিও শুনবেন।
Whatever I shall utter, you will listen to that and he will also listen to that.
কারণ আপনাকে এমনি বললে আপনি বুঝতে পারবেন না।
Because you will not understand if I uttered these words only to you.
Not be able to understand.
Not be able to understand. Simple sentence, sir. ছোট ছোট করে।
DD3 of Block A of the judge's brief of documents. Tell my lord, what is this document about?
এই ডকুমেন্টটা দেখুন এবং মাইলর্ডকে বলুন এটা কি ব্যাপারে।
এই ডকুমেন্টটা হলো মিস্টার রবিন ব্যানার্জি, চার্টার্ড অ্যাকাউন্টেন্ট, আমাকে 23rd January 92 তে একটা চিঠি দিয়ে ওনার ওই রিপোর্টটা এর সঙ্গে দিয়েছিলেন। এটা সেই চিঠিটা, এখানে মিস্টার রবীন ব্যানার্জি সই
This is a
রয়েছে।
letter that was sent by Mr. Robin Banerjee. The letter is dated 23rd January 1992. এর চিঠির সাথে কি পাঠিয়েছিলেন?
চিঠির সঙ্গে উনি ওই হাতে যেটা লিখে এনেছেন সেই কাগজটা ছিল।
Along with this letter, he sent me the handwritten note or the document, handwritten note or the document.
আর এর সঙ্গে ওই রিকুইজিট ফিজের ওই চালানটাও বোধহয় আছে।
Along with there was the challan of the requisite fee. এই ডকুমেন্টটা কে তৈরি করেছেন?
এটা রবীন ব্যানার্জি তৈরি করেছেন, ওনারই সিগনেচার, আমি চিনি ওনার সিগনেচার।
This document was prepared by Mr. Robin Banerjee.
He is author of this
He is
letter.
the author of this letter. His signature appears on the document, and I am acquainted with his signature. এই
Yes.
document, yes, true and correct. এই দাও। আরে লেখা যাবে না তো।
কবে আগে মার্ক হয়েছে?
হ্যাঁ, ওটা গেল না তো, ওটা গেল না, ওটা পার্ট গেল।
আরে ছোটগুলো
অন্য পার্টটা গেল না।
কি করেছো তো? স্যার আপনি একটা সেন্টেন্স বলবেন, আমি একটা বলবো, তারপর আপনি আবার একটা বলবেন স্যার, ছোট ছোট করে স্যার, কমপ্লেক্স না তাহলে যাবে না ঠিক করে।
Mr. Roy,
হ্যাঁ,
I'm handing over to you two documents.
হ্যাঁ,
Which are also part of 83 of the judge's brief of documents.
রাইট।
Kindly see these documents and tell my lord what are these documents about.
এই ডকুমেন্ট দুটো দেখুন এবং মাই লর্ডকে বলুন এগুলো কি ব্যাপারে।
এর একটা ডকুমেন্ট তো হচ্ছে যেটা উনি ওই ফিজটা জমা করেছিলেন আরওসিতে তুলবার জন্য, এটা সেই কাগজটা।
One of the document is the fees received which was deposited on the ROC, the register of office of the register, which was deposited in the office of the register of companies. And the another document is
আরেকটা কাগজ হচ্ছে উনি ওই ডিফেন্ডেন্ট নাম্বার 3 বিনাগুড়ি ইনভেস্টমেন্ট কোম্পানি রেজিস্টার অফিস P15 ইন্ডিয়া এক্সচেঞ্জ প্লেস, এটা ডেট অফ ইনকর্পোরেশনের সময় ছিল। এই কোম্পানির যে ফান্ড পজিশন এবং ডাইরেক্টরসদের ডিটেলস এখানে লিখে এনেছিলেন। এবং
and the another document is about the fund position and details of the directors of Binaguri Investment Private Limited, which was at the time of inception was situated at P15 India Exchange Place, right?
উনি দারিক বাবুকে এই কাগজটা দেখিয়ে বললেন,
উনি means
রবীন ব্যানার্জি,
one second sir, showing this document to Mr. Darik Nath Bhattacharya, Mr. Robin Banerjee told that
যে দারিক বাবু আপনি আমাকে দিয়েছিলেন আপনি আমাকে এই কাজটা দিয়েছিলেন,
you gave me the task or job task,
যে বিনাগুড়ির শেয়ার হোল্ডিং আর ফান্ড পজিশনটা দেখার জন্য,
to find out the share and fund position of Binaguri Investment Private Limited
company,
the company namely ওটা
প্রাইভেট লিমিটেড। আমি এটা দেখে আশ্চর্য হয়ে গেলাম,
I am surprised to see that
যে রেলেভেন্ট ডেটে মিস্টার রায় আমাকে জিজ্ঞেস করেছিলেন যে ওই 81 ওই সময় থেকে বিনাগুড়ি ইনভেস্টমেন্ট কোম্পানির ফান্ডে রিকোয়ার্ড ফান্ড ছিল কিনা তাতে
কি গেল ওটা আগেরটা? I am surprised to see that what Mr. Roy has asked me at that relevant point of time, that is 81, 82,
81
81, there were sufficient funds in the
bank account
of
or
Binaguri,
in balance sheet
in the bank account or in the balance sheet of Binaguri Investment Private Limited
company.
company.
আমি দেখলাম
I saw that
যে ওই রেলেভেন্ট সময় থেকে বিনাগুড়ি ইনভেস্টমেন্ট কোম্পানির এইরকম ফান্ড পজিশন ছিল না যাতে করে
I saw that at that relevant point of time, Binaguri Investment Private Limited Company did not have the fund position by which
sufficient fund position
did not have sufficient fund position by which
যাতে করে ওরা এই কোম্পানি হাইকোর্টে অকশনে এত বড় সম্পত্তি কেনবার জন্য অকশন অ্যাটেন্ড করতে পারে
by which they can attain this huge amount of property, that was by which they can participate in the auction of this huge amount of property that was held by High Court.
উনি আরো পয়েন্ট আউট করলেন
He pointed out that
অঞ্জন বাবু প্লেনটা একটু দিন তো প্লেন
স্যার বলুন।
উনি ফার্দার পয়েন্ট আউট করলেন যে এই কোম্পানির অথরাইজ ক্যাপিটাল 10 লাখ টাকা।
He further pointed out that the authorized fund of this company is
authorized
capital of this company is 10 lakh rupees, around 10 lakh rupees.
যার মধ্যে পেড আপ ক্যাপিটাল হচ্ছে 4,02,000,
out of which the paid up capital is 4 lakhs rupees.
4,02,000.
4,02,000 rupees.
আরেকটা জিনিস উনি দেখালেন,
another thing he pointed out is that
দেবেন্দ্র বাজোরিয়া,
বলুন স্যার,
দেবেন্দ্র বাজোরিয়া ডিফেন্ডেন্ট নাম্বার 1 এর নামে 25শে জুন 87 4,000 শেয়ার কোম্পানির দেওয়া হয়েছে।
He again pointed out that 4,000 share of the company was given in the name of Devendra Bajoria, who is defendant number 1, in 25th June 1987. On 25th June 1987. 4,000 share. 4,000 share.
যেটা ইন্ডিকেট করছে যে এই 4 লাখ টাকা, 4,000 শেয়ার মানে 4 লাখ টাকা
বলুন
কোনো চেকের উল্লেখ নেই, উইদাউট চেক, এবং উনি ভালো করে ইন্সপেকশন করে দেখেছেন যে এটা ক্যাশ ট্রানজাকশন হয়েছে, 4,000 শেয়ার ক্যাশে নিয়েছে, অ্যালার্ট করা হয়েছে, কোম্পানি নিয়েছে,
which indicates that 4,000 share, which is equivalent to rupees 4 lakh, there is no mention of the check on the inspection. It was found and it was done in cash transaction. There is no mention of any check and it was done in cash transaction. On inspection, it was found that it was done in cash transaction.
Next.
Further.
Next. Put the question.
এখানে আরেকটু বলার আছে।
What is this document? Show it to me.
on which was the chartered accountant. Work of the company, the different number 3.
বলবে না, জিজ্ঞেস করো কি বলছো।
My lords, please, can I have a look at this?
ইয়েস, ডকুমেন্টটা একবার দেখি।
ডকুমেন্টটা স্যার ইয়েস স্যার বলুন। ফার্দার ইন্সপেকশন
যে 31st মার্চ 89-এ এই ডিফেন্ডেন্ট নাম্বার 3 কোম্পানির ব্যালেন্স শিটে $3,70,902 এটা ডিপ্রিসিয়েশন দিয়ে 70,902 ল্যান্ড অ্যান্ড বিল্ডিং বলে দেখানো হয়েছে।
on the balance sheet of the defendant number 3 company in an entry on 31st March 1989, an amount of rupees 3,70,902 has been shown as in
as land and building after depreciation. এখানে আরো নোট করে দিয়েছেন উনি যে ইন্ডিয়া এক্সচেঞ্জ প্লেস থেকে অফিস,
he has made a further note here that from Indian
এক্সচেঞ্জ প্লেস যেখানে এর অফিস ছিল সেই অফিসটা ট্রান্সফার হয়ে
from Indian exchange place the office was transferred to
3 নম্বর নেতাজি সুভাষ রোড,
number 3 Netaji Subhash Road,
ক্যালকাটা 1 নে এসেছে এটা 20th November 79-এ
on 20th November 1979.
তার মানে হচ্ছে immediately before purchasing the suit property,
which means immediately before the purchasing of the suit property. এই ডকুমেন্টটা কে লিখেছেন?
এটা লিখেছেন রবীন ব্যানার্জির হাতে লেখা।
This was handwritten by Mr. Rabin Banerjee.
Aware of his handwriting?
হ্যাঁ,
কি ওনার হাতের লেখা চেনেন? Yes, I know his handwriting. এই ডকুমেন্টে যা লেখা আছে তা কি সত্য এবং সঠিক?
একদম সঠিক,
true and correct.
Document handed over to you. Next, to the letter dated 23/1/1992, which is just been marked as Exhibit E.
হ্যাঁ
এই ডকুমেন্টের সাথে কি এক্সিবিট ইটা আপনাকে দেওয়া হয়েছিল?
হ্যাঁ দেওয়া হয়েছিল, আর তার সঙ্গে এই রসিদটাও দেওয়া হয়েছিল। উনি
along with this receipt was also given to me. This
receipt of ROC.
This receipt of ROC was also given to me. ROC date লিখে নাও। ROC dated 23rd January 1992 was also handed over to me.
Date of the document issued by Register of Companies.
Register of Companies যে document
23rd January 1992.
The document is dated 23rd January 1992.
Then, my lord, for what reason this document was issued by the Registrar of Companies?
কি কারণের জন্য রেজিস্ট্রার অফ কোম্পানিজ এই ডকুমেন্ট ইস্যু করেছিলেন?
এটা ইন্সপেকশন নেয়ার জন্য আমার অ্যাটর্নি দ্বারিকনাথ ভট্টাচার্যের পরামর্শ অনুযায়ী, অ্যাডভাইস অনুযায়ী আমি রবীন ব্যানার্জিকে আরওসি থেকে তুলতে বলেছিলাম।
To make an inspection at the instruction of my advocate Dariknath Bhattacharjee, I told Mr. Robin Banerjee, my
চার্টার্ড অ্যাকাউন্টেন্ট, সিনিয়র চার্টার্ড অ্যাকাউন্টেন্ট,
to কি করতে বলছেন?
to personally go
To personally go and collect this document.
have an inspection, to hold an inspection.
Collect this document from
Collect this information.
document.
Yes.
কত
কত হবে?
ই হলো এটা বোধহয় এফ হবে না? কালেক্টিভলি দুটো আছে।
সব collectively. সব collectively.
স্টেপল থাকবে? Exhibit F collectively. Sir, simple sentence বলুন স্যার, we are making complex and compound sentences.
Kindly see answer to question 63 of the deposition dated 10th of September 2020.
এটাতে নেই স্যার।
Tell my lord, what steps did you take for training the document of 1971?
63 নম্বর উত্তরটা দেখুন আপনার প্রশ্নটা। শোন কোয়েশ্চেন নাম্বার 63 এবং বলুন 1971 ডকুমেন্ট। কোয়েশ্চেনটা কি গেল? লাস্ট একটু করে বলুন। 1971 ডকুমেন্টটা তোলার জন্য আপনি কি স্টেপ নিয়েছিলেন? What step did you take for obtaining the document of 1971? Yes.
আমি 1971 এর যে গিফট ডিডটা সেটা তোলার জন্য আমি চেষ্টা করেছিলাম।
I tried to obtain the gift document, that is the gift deed of 1971
deed, কিন্তু আমি
বলুন
ওই বিফোর ফাইলিং অফ দ্য স্যুট এটা হাতে পাইনি।
But I did not receive the document before the filing of the suit.
কারণ
because
ওই সময় যেখানে যে অফিসে রেজিস্ট্রি হয়েছিল সেই অফিসটা বেহালায়, সেই জায়গা থেকে
because at that point in the office in which the registration was done, the office at Behala in which the registration was done,
সেটা অন্য জায়গায় উঠে চলে গিয়েছিল,
was shifted to another place.
যেহেতু 71 এ কি ঘটেছিল বা কোথায় রেজিস্ট্রি হয়েছিল এটা আমার জানা ছিল না।
As I was not aware what happened in the year 1971 or where the registration was made in the year 1971,
আমি এবং দারিক বাবুর লোকেরা মেন রেজিস্ট্রি অফিস, যেটাই গভর্নমেন্ট প্লেস ইস্টে ছিল তখন, আর
কোথায় ছিল?
গভর্নমেন্ট প্লেস ইস্টে,
গভর্নমেন্ট প্লেস
ইস্টে ছিল। আর আমি আলিপুরে এসআর অ্যান্ড ডিআর এই তিনটে জায়গায় দারিক বাবু সার্চ করেছিলেন।
যেহেতু অ্যাওয়ার্ড ছিলাম না, এটা গেছে তো। হ্যাঁ হ্যাঁ হ্যাঁ। হুম। I, along with Darik Babu, went to the government place East, Alipur SR.
আমার লোক গিয়েছিল, আমি যাইনি। আলিপুর গভর্নমেন্ট প্লেস ইস্টে দারিক বাবু লোক পাঠিয়েছিলেন, আর আলিপুরের এসআর ডিআর এ লোক পাঠিয়েছিলেন।
আপনার লোক না দারিক বাবুর লোক?
দারিক বাবুর লোক।
Darik Babu sent his person to government place East and Alipur SRDR. SRDR in search of the document. In search of the document.
এই ডকুমেন্টটা,
this document,
আমি এর আগে আমার ডিপোজিশনে বলেছি,
as I mentioned previously in my deposition, this document,
আমি অরিজিনালটা পাই much later after filing of this suit from the
I received the document much later after filing the document. Previously, I received this document much later after filing this document, filing the suit.
I discovered this document from the
I discovered this document from the
residence of Nolinakho Chattopadhyay. Nolinakho Chattopadhyay, advocate.
He has already deposed in question number 55. Answer to question number 55, this has already been deposed. So need not repeat what has been stated only.
আর কিছু বলবেন স্যার? আর কিছু বলবেন? নলিনাক্ষ চট্টোপাধ্যায়।
নলিনাক্ষ চট্টোপাধ্যায় বাড়ি থেকে আমি
অ্যাডভোকেট
উনি মারা গিয়েছিলেন। নলিনাক্ষ অ্যাডভোকেট। After his death.
After his death.
Yes.
I discovered the document from the residence of Noliakho Chattopadhyay after his death.
And now showing you a document, shows that P7 of the judge's report document. Can you tell my lord what is this document?
এই ডকুমেন্টটা দেখুন এবং মাই লর্ডকে বলুন যে এই ডকুমেন্টটা কি ব্যাপারে।
এটা plaint of suit number.
The document is a plaint of suit number
42 of 1980.
42 of 1980.
Which was filed by Devendra Bajoria, defendant number 1.
Devendra Bajoria, defendant number 1.
Against my elder brother Shubir Rai, defendant number 2.
Against my elder brother Shubir Rai, defendant number 2.
Yes. Next. Copied out of certified copy of the plaint.
Certified copy.
Plaint বললো না, এটা বললো this is a
এটা certified copy of the plaint.
This is a certified copy of the plaint. Plaint বললেন তো ওটা? This is a certified copy of the
copy of the plaint. এটা দারিক বাবু ওনার ক্লার্ককে দিয়ে হাইকোর্ট থেকে আমাকে তুলে দিয়েছিলেন।
This document was obtained by Mr. Darik Babu by his clerk. Obtained from this document was obtained by Darik Babu. This document was given to me by Darik Babu.
Certified.
Which was obtained by Darik Babu.
Can you tell my lord whether any immovable property was the subject matter of this particular suit?
কোনো অস্থাবর সম্পত্তি কি কোনো বিষয় ছিল?
এটার সাবজেক্ট ম্যাটার ছিল 24/2 আলিপুর রোড, ক্যালকাটা, 27.
The subject matter of this suit was 24/2 Alipur Road, Kolkata 27. Property, right? The
Property.
property which was at Koredin. The subject matter of the suit was the property that was situated at 24/2 Alipur Road, Kolkata 27.
এরিয়াটাকে আমি ভলেন্টিয়ার করবো।
Yes, next.
Describe the extent of the immovable property which was the subject matter of the instant suit.
এই যে জায়গাটার
This 24/2 Alipur Road
is 24/2 Alipur Road
was consisting of 2 bighas, 11 kathas,
11 kathas,
slightly more than 8 chataks of land.
Slightly more than 8 chataks of land. 8 chataks of land.
It includes palatial building,
It includes a
palatial 2-storied building,
palatial 2-storied building, palace,
with huge servants' quarter
with a huge servants' quarter
and double tennis court. And garden, etc.
And garden, etc.
Roy, holding about your document shows as eight.
এক্সিবিট করাবেন কি এটা? এক্সিবিট বলেননি স্যার।
মার্কেট
এক্সিবিট FG হবে তাহলে।
ওটা ওইখানে ইনকর্পোরেট করুন যেখানে সার্টিফাইড কপির কথাটা বললো পঙ্কজ বাবু, ওইখানে ইনকর্পোরেট যেখানে সার্টিফাইড কপির কথা বললো, দিস ইজ এ কপি অফ দি প্লেন, সার্টিফাইড কপি অফ দি প্লেন, ওইখানে মার্ক করুন।
সার্টিফাইড কপি অফ দ্য প্লেন বলেছেন ওখানে। জি অঞ্জন দা, জি তো স্যার কোয়েশ্চেনটা কি বললেন এটা? এই ডকুমেন্টটা কি ব্যাপারে মাইলর্ডকে বলুন।
This document is relating to one order passed on 12th February 1980
passed on 12th February 1980
by Honorable Justice Mrs. Podda Khastogir,
Honorable Justice Mrs. Podda Khastogir,
an interim order was passed
and an interim order was passed
in favor of defendant number 1 Devendra Bajoria plaintiff
Devendra Bajoria plaintiff.
What is the case number in this?
42 of 80, my lord.
I কি interlocutory application? What is the case number?
42 of 80.
Is it a suit or a interlocutory application? What is this? Suit. Yes.
আপনি কি বললেন? দেবেন্দ্র বাজোরিয়া বললেন, আবার প্লেন্টিফ বললেন স্যার।
হ্যাঁ, দেবেন্দ্র বাজোরিয়া এখানে প্লেন্টিফের ফেভারেই এটা ইন্টারিম অর্ডারটা পাস হয়েছিল। প্লেন্টিফ হিয়ারিং
এই মামলায় ডিফেন্ডেন্ট নাম্বার 1
In favor of defendant number one, Devendra Bajaj.
or Devendra Bajoria.
Yes.
Therein. Therein.
42. 42 of 80. কিছু বলবেন?
Since it's a certified copy, my lord,
It's a certified copy.
Yes.
Exhibit H.
Sir, what? I'm handing over to you another document. It's disclosed as serial number 70 of the judge's piece of document in DD number 6 of the judge's brief. Kindly tell my lord, is this document?
এই ডকুমেন্টটা দেখুন এবং মাই লর্ডকে বলুন এটা কি ব্যাপারে। DD6 হতে চাই।
This is the certified copy.
This is the certified copy
of decree passed in favor of Devendra Bajoria on 22nd May 1980. আমি এখানে একটু ভলেন্টিয়ার করতে চাইছি একটা লাইন।
The witness volunteers.
The suit was filed on 17th January, my lord, and decree was passed on 22nd May 1980, within 4 months.
Eighty. 22 May 1980.
Within 4 months.
Yes.
Was this legally passed by this?
Decree was passed in favor of Devendra Bajoria, the plaintiff of suit number 42 of 80.
Was the value of the decree passed in such suit?
চোখটা খারাপ থাকে আমার একটু পড়তে অসুবিধা হচ্ছে।
এটা কি যাবে? এটা কি যাবে?
পাইলট আমি ভ্যালুটা বার করতে পারছি না, আমার চোখ খারাপ তাই।
I cannot find out the value from the document as I have an eye problem.
Will you be able to indicate on the next date?
আপনি কি
আমি এখনই বলতে পারি 4 লাখ টাকায় 4 lakhs for a paltry sum of rupees 4 lakhs only.
4 lakhs only. ডিক্রি ভ্যালুটা কত ছিল? 4 lakhs only. ওকে, বলে
Will be executed. The decree of the author.
Is it a certified copy of this?
Certified copy, my lord.
exhibit I.
How did you procure these procure the certified copy of these documents?
সুটের সমস্ত কাগজ দারিকনাথ ভট্টাচার্য ওনার ক্লার্ককে দিয়ে হাইকোর্ট থেকে তুলে দিয়েছিলেন আমায়।
All the documents of this all the documents of this suit was obtained by Mr. Dariknath Bhattacharjee,
advocate,
Advocate Dariknath
advocate
Bhattacharjee,
solicitor.
who through his advocate solicitor Dariknath Bhattacharjee, who through his clerk or obtained this document from court.
What steps did you take after obtaining the certified copy of the cause records of the 1980 suit from this honorable court?
সমস্ত কজ রেকর্ডস এর সার্টিফাইড কপি তোলার পর 1980 স্যুটের কজ রেকর্ডস এর সার্টিফাইড কপি তোলার পর কি স্টেপস আপনি নিয়েছিলেন?
আমাকে ইনিশিয়ালি এই কাগজপত্রগুলো তোলার পর দারিক বাবু আমাকে ইনস্ট্রাকশন দেন যে তুমি এখন কোনো স্টেপ নেবে না।
After obtaining all those documents, initially Darik Babu instructed me not to take any step.
Immediately,
not to take any step immediately.
Or you should not discuss this matter even
should not discuss the matter
even within your family also.
Within your family also.
I'm showing you a document. The judge's brief of document. And we tell my lord, what is this document?
Page number?
Number 79.
PD 14 appearing at 79 of the judge's brief of document.
Consider 8 double H. Consider 8 double H.
What is this?
This is sale deed.
This is the sale deed.
This is the sale deed passed. The sale deed executed on the basis of Honorable High Court's order by my elder brother Shubir Rai, defendant number 2, in favor of auction purchaser Binaguri Investment Company, defendant number 3 herein.
Binaguri Investment Private Limited.
How did you obtain this document?
এই কাগজটা দারিক বাবুই তুলে দিয়েছিলেন, কিন্তু অরিজিনালি দারিক বাবু তুলে দিয়েছিলেন, কিন্তু যেহেতু এটা জেরক্স ছিল, এটা সব মার্জড হয়ে গিয়েছিল এই এতদিনের ভেতরে। এটা সাবসিকুয়েন্টলি আমার পরবর্তীকালে
This document was obtained by Darik Babu.
We will complete.
As this document was in Xerox photocopy, as this document was a photocopy.
Okay, easily stop kore daw question দিয়ে।
Photocopy তারপর বলবো।
ফটোকপি, এটা কিছু পড়া যাচ্ছিল না।
The inks were smudged. Inks of the documents were smudged.
In 2006
smudged
হয়ে গিয়েছিল। 2006 এ
in the year 2006
আমার তখন সলিসিটর ভাস্কর মিত্র এটা আবার কপি তোলেন।
My then solicitor Bhaskar Mitra obtained another certified copy of the said document.
The date is 14th February 1981.
The date is 14th February. Now obtain করেছিলেন কবে?
14 February 1981. এটা সেই সার্টিফাইড কপি।
The date of the certified copy.
Date of the instrument. এটা my document.
Yes. This 14 February. J.
Asha. Little please. You stop here.
Based on the document accommodating us in the suit of 1996. Finally, we have been able to produce evidence. Only one indulgence have a systematic January subject to document time considering based on consecutive days for a document fixes the money. 30 years would
2 days you will complete.
try, I don't definitely try.
Gotcha.
If the logic is the whole case, maybe in between consecutive days in the week.
Okay. Okay, no. Witness Gautam Roy. Mr. Gautam Roy is examined in part. The documents in a mark with a number to call them. Documents are marked exhibits. দেখে একটু করে দেবেন for further examination. Please this matter on অঞ্জন বাবু কবে যাবে? হুম হুম তাহলে ফেব্রুয়ারিতে দিয়ে দিন।
এত ক্লজ ঢুকাচ্ছেন সেন্টেন্সের মধ্যে।
ফোর্থে দেখুন, ফোর্থ ফেব্রুয়ারি হতে পারে। 4th February. Not another day. I'm giving you 4th. Let's see what happens in 4th. If required, then 5th or 6th consecutive date we can fix. Huh? Let us first do it. 4th is 2 p.m. Tuesday, 2 p.m. ওই দেখো আবার কি বলছে। 5th দেখুন, 5th is commercial then. 5th এবার ফার্স্ট হাফ হয়ে যাবে। Then on 6th February.
The last occasion, considering the report of joint special officers, my lord was pleased to direct the parties to obtain suggestions on which were given by the joint special officers, my lord, to regard to proper administration of the estate.
You have got the report?
Yes,
Who is for the petitioner? 5.
10, my lord, I do appear for the
রিপোর্টটা দিন তো। আর অ্যাপ্লিকেশন কপিটা দিন।
সবাইকে মেল করা আছে।
GA 5টা দিন। GA 5.
Were made in the paragraph of 1 onwards, my lord.
The new board will take consider all the and where is Mr. Boral who was appearing for the petitioner? So 5 will be disposed of today.
Also make one prayer, my lord. I am appearing on behalf of Mr. Das and Mr. Mitru, the special officers appointed. Since the new committee, my lord, is in force and acting, I was praying for discharge of the joint special officer. That is only limited.
In which page the elected members have been indicated?
Paragraph 30, page 11.
The result of the election.
Debrajmi,
This will be for a period of how, which, for 3.
That's the order, my lord, of Honorable Justice Chakraborty.
Okay.
Can I just place one thing, my lord?
Yes, Mr. Dotto.
What I have considered, my lord, the report, I think that to my limited understanding, the special officers appointed by Lord should, for the time being, continue. Let the trustees do their functions, but there should be a supervisory persons who would supervise the activity. He might object. He might have
There is.
I don't know whether.
No.
No. There will nothing of conflict of interest. Everything.
So we'll
should
see
be-
how it functions.
That's
If there is any such grievance, the parties are at liberty to approach this court and intimate that what is happening in,
no.
so that we can decide on this issue. But
One more thing, I do appear for the one of the beneficiaries, Mr. Ajunta De. Now, each of the beneficiaries is entitled to certain monies from the annuity surplus. Now, I was getting it. My predecessor in interest was getting it. Now, after I came into the picture, I submitted a claim to the erstwhile trustees. They declined it on one pretext or the other. And that's the principal reason I came before. No, please do. Let my learned friend, let my learned, because it's a, no, because the applicant happens to be an 80-year-above-old lady. Now, my respectful submission is that let my claim be considered, my lord, by this supervisory receivers who will adjudicate my claim and give me because my claim is very minuscule. It's around 35 or 40 rupees a month. That's a Rajbari members get, each of the members according to their shares. Less also, 7 rupees, 10 rupees, 40. I have a major share. I have given how I am entitled to. If the supervisory board sits one day and decide my case in the presence of the trustees.
this is a prayer in your application.
That's my prayer. That's my principal prayer. Please read the application. Please read the application. Madam, will kindly see IAGA H 10 mileage prayer G.
No. What I do is accept who have been elected to constitute the new board. I give you liberty to file a fresh application before the new committee, who will consider your representation. If there is any grievance, that will be, because continuing the special officers will not inure to any benefit, because they have been fixed to hold the election.
Only absolutely, man. One thing. Why I want the super.
What is the inform that? The ex-trustee, the two of the ex-trustees
Now, and the order with regard to sale, to have decided about the justice segment. It's running to the base melon. If the board is formed, and the trustees who are the instances, be appointed again. Records
Not appointed, elected, sorry. See, what will be the order in the appeal that will have a effect on this, but this cannot be stayed. No? They have to be discharged. Let the new board function. If there is any such direction from the honorable division bench, that will be carried out.
That would create a great difficulty.
What is the difficulty?
Difficulty in the sense, my lord, if the it is on record that they have sold the property, whatever my lord has hold the jurisdiction that this court has no jurisdiction to entertain the sale, to set aside the sale. But it is on record they have, without seeking any permission, what they have sold the property. Whatever may be, that is on record.
Participated in the election, my lord.
Whatever, I have my clients has participated in the
Seeing the result.
not challenging the result. It's on. We have challenged.
The order is not stayed. No?
No. Appeal is running in the list, my lord.
This order is not stayed. Let the election, what is the report of the special officer be accepted, the new board? No.
It could come to an end.
What will be the effect? See, if the sale, what has been held by this court, is not proper, suppose. Huh? Then let it be dissolved. If there is an order of the appellate court, they will be dissolved. A fresh election will be conducted. But if there is no stay, what is the use of holding the special officer for another 15 days or 20 days? I gave you time, Mr. Boral. I gave you time till 19th today. Almost 15 days you got it. There is no order of stay. Why should they continue? Why should the special officer continue now?
They have their faith from the new board member.
Is he for representing the board? Is he representing the board?
Ashun. No. If there was an order of stay, no. In compliance to the order passed in GA 5 of 2022, election for electing for formation of new board of trustees to the estate of, what is the name of this estate of Raja? Raja Sir Radha Kanto Dev Bahadur. On perusal of the report filed by the special officer, it is found that the special officer or joint administrator, the joint administrator declared the results of the election and published the list of the newly elected for forming the board of trustees as follows. Paragraph 30 te naamgulo dewa ache. It is also indicated in the report of the joint administrators that none of the sevayates have raised any objection with regard to process and or method of voting for the election. On the contrary, the sevayates expressed their satisfaction to the manner the entire voting process was conducted by the joint administrators. In view of the above, upon considering the report of the joint administrators, the following persons, namely Debraj Mitro, Sanjeev Mitro, Shoibal Dev, and Soumit Dev are appointed as the new trustees of the Board of Trustees of the Trust Estate of Raja Sir Radhakanto Dev Bahadur, since deceased. The said trustees shall discharge their duties in terms of the order dated 7th October 1996, as confirmed by order dated 9th April 1999. The Board of Trustees shall be entitled to act by the majority decisions of the trustees. Which should be the commencing date for 3 years?
On the date of election, when the results were declared.
When was the result declared? No, formation, it will begin from which date?
Declaration of the result of the election.
24th November. As
Which-
suggested by the applicant and other Sebaits, the life of the new Board of Trustees shall be valid for a period of 3 years with effect from 24th November 2024. After expiry of such period of 3 years, the Sebaits shall be entitled to select new trustees of the Board of Trustees by election, subject to confirmation by this court. Para. Mr. Meghnad Dotto is to be disposed of.
No, my lord, there are several other
Prayers.
What I
Mr.
would
Meghnad
suggest,
Dotto, learned advocate for one of the Sebaits.
I have one of the beneficiaries.
One of the beneficiaries submits that his client has not received
her client.
her. His client, no, he or you.
Yes. No.
How come you become her?
Yes.
His client has not received the, what is that amount? What you have not received?
This annuity and surplus amount.
Annuity and surplus amount. Despite approaching the previous board.
File a report, my lord, they can file.
What is her name?
Ajanta De.
Ajanta De. Beneficiary is granted liberty to approach the new board for redressal of her grievance relating to payment of annuity and surplus.
Let them decide this issue.
GA 5 of 2022 stands disposed of. 10, he has other prayers also.
My lord, there's a new the newly constituted board will consider my claims within a certain period of time. Otherwise,
Which shall be considered within a period of 1 month of submission of such representation.
Absolutely.
Number 8.
The joint administrators duties of joint administrators shall be discharged. Achha. Mr. Bodal, learned advocate for applicant in GA 8 of 2024, 2023, also submits that what are the prayers? The liberty be praised that the liberty is granted to his client to approach the new board for consideration of his prayers made in GA 8 of 2023. Liberty granted to approach the new board. Sanjay Shah, or client number Sanjay Shah. Application being GA 8 of 2023 stands disposed of.
Only with my lords.
And the next matter
my lord will recall it was an advertisement was made pursuant to your lordship's order. We want to sell a property. But the special officer is here, kindly fixes it tomorrow at any particular time, or my lord on
For
Monday.
that matter, he did not make the payment. That was. Yes.
This is a matter where we are trying to put up for sale because of the trust.
Previous order was confirmed, but he did not make payment. That matter.
No, not that way. Not that way.
But I am appearing for the intending purchaser.
Yes, partly that. And my lord,
One of the properties
yes,
confirmed, race 2 was not
three
confirmed.
properties have now come. One was there. My lord, now the special officer is also here. My lord,
I am appearing, my lord, for the intending purchaser.
Tomorrow.
I don't
Kalki
want
kota
to.
sum. Tak? Tomorrow. Not. Yeah, okay. If any of the juniors may come.
Great.
Yeah.